Lordship, I beg to mention item 15. Item 15, currently this matter may be listed after the vacation, Your Lordship.
Heard Mr. I. Imchen,
Yes, Your Lordship.
learned counsel for the respondent. Also heard Miss what
Mika, Lordship.
Mika H.I., learned counsel for the revision petition. Learned counsel for the respondent prays for an adjournment. And the counsel for the petitioner does not opposes the said prayer, hence the prayer is allowed. Let this matter be listed after 2 weeks.
Yes, Your Lordship. Much obliged.
May I please your lordship? May I please your lordship?
Pleasure, Lordship. Lordship, item number 3. Admission. Let this matter will come up after part 1. This is
Lordship, just a short matter. Yes, after the first part for admission hearing.
Today,
Yes, Lordship, just a short matter.
okay.
yes, yes.
Am I audible, my lord?
No, just a minute. There is a mention on PC.
May I please your lordship?
Albert, yes, the sound is not coming. Yes.
Am I audible, my lord?
Yes, Mr. Borgo, hi.
My lord, I would like to
No, you are
seek
not
this for.
audible.
My lord, your lordship has to unmute me.
You want to mention something,
My lord,
but you are not audible. Let them fix up the you can mention after some time, because unless you are audible. Yes, Mr. Borgo, hi.
my lord,
No, not audible. Take up other matters, let them fix it up.
For judgment, item number 1.
For reasons mentioned in the judgment, this court is of considered opinion that the petitioner who has already served continuously for 33 long years is entitled to get his services regularized, and therefore the respondents are hereby directed to regularize the services of the petitioner for the reasons mentioned herein before, within 3 months from the date of this order.
From the supplementary cost list for admission, item number 23.
Mr. Angami, this is wrongly fixed for admission. It should have been for delivery of orders.
Okay.
So I am for reasons mentioned in the order. This court is of the opinion that embargo of section 37 of the NDPS Act is not applicable in the case of the present petitioner. And as the present petitioner has already undergone 135 days of detention his further custodial detention does not appear to be necessary for the sake of fair investigation. And therefore, he is allowed to go on bail of rupees 30,000 with one surety of like amount to the satisfaction of learned special judge NDPS Kohima with following conditions: that he shall cooperate with the IO and shall appear before the IO as and when so required by the investigating officer for the sake of investigation, and some other conditions are imposed.
For admission, item number 2.
I'm the respondent number 2, my lord.
After today itself. Okay.
For admission, item number 4.
His lordship. Lordship, this matter can come up on 6th of November for admission hearing, lordship.
6th of November.
After vacation, lordship. I've taken the consent.
Heard Mr. N. Muzoi, learned senior government counsel. Also heard Mr. I. Im Chen, learned counsel for the petitioner. Learned counsel for both sides praised for listing this matter on the 6th of November.
Lordship.
Admission hearing.
Lordship.
Considering the submissions made by learned counsel for both sides, the prayer is allowed. Let this matter be listed on 6th of November for admission hearing. The interim order shall continue till next day.
Oblige, your lordship.
For admission, item numbers 5 to 7.
Particular. The lawyer is not on the line. When it was listed on last occasion, no, the date of listing was yes, right. Okay. On the newly impleted response. Mr. Chaudhary, can we go ahead with hearing? Is there any
Yes.
impediment?
Talking to my friend, Lordship, I'm not keeping well from last day. Yesterday. It will be longish matter, Lordship. Maybe I cannot take it today.
Okay, what is?
Only reverse time. Watching a lot of implications are there. I mean, with no problem.
No, but what? Consider.
Is not practically not well also.
November code. Can it be in the week commencing 13 November, Lordship?
I don't have any. You are not well.
I'm not well, Lordship.
He appears to be.
Yes. For the purpose, I can't obtain for my only brother is it.
Because unless we,
other than you will mentally prepare, because the matter has been first week's by this court and keeping this matter for 2 days.
yes,
Because it was not possible, I have said, to make it very short also it takes time. But this is something which is.
no, it requires, yes.
There are other, I have seen lot of judgments are there. Often I go by understand, try to collect it. Your lordship, we are also enlightened. Because ultimately, these are very rare cases.
Yes,
Your lordship knows 2002. The act, but number of cases are very less.
no, I would have liked to hear the matter, but for,
But I,
unless we hear Mr.
no, otherwise your lordship can please partner. Lordship just here for 10.
Keeping it heard would,
Why normally now, I don't know, lordship, there is, it is better is partner, because the lordship is already started telling this. Starting to. Now there is one notification, I have been told that it is also can be by the virtual mode. I am not trouble you, my unnecessary language, I know. But if I can just proceed for half an hour also, at least I think nothing like Manivan. But I.
no, why to trouble him?
No, I told him that he's very unclear. I actually in the morning and I was thinking that why he's sitting like that.
No, we are adjourning this.
That's it.
It may not be proper.
No, I also, I, why are you just, only difficulty is that you also has heard this matter, it's not that. In between the problem came on, proctor, or technical glitch the problem came on. But you also just recollect that you also partner this matter. So you also can partner.
Now, keeping it partnered would create other difficulties. Let it be fixed in the, as prayed for in the week commencing from 13th of November.
If it is.
It may be on a fixed date if you pray.
Only on 28th is possible.
Heard Mr. D. Das, Learned Senior Counsel, assisted by Mr. S. Das, Learned Counsel for the petitioners. Also heard Mr. R. K. Dev Chaudhary, Learned Deputy Solicitor General of India. As Mr. R. K. Dev Chaudhary is not well, it may not be possible to conduct hearing of this case today. And on the prayer of Learned Counsel for the both sides, this matter is fixed on 28th of November for.
But this one. Your lordship, on this matter. That is the partner matter, because I think your lordship, it will be easier. At least your lordship has gone ahead in this case.
No, actually, you have started only.
No, yes, it started. Again, I have to start. At least some, your lordship has got that particular thing.
No, because this is. And I don't know when I will be coming back to Kohima. And this, we see there are difficulties you have seen just now. It would create problem. It would be. So I am not in.
Very happy that this matter is in. But we can't do it because your lordship can't do it because there is one judgment where it says that roster entry is for chief justice.
Yes.
Your lordship can't take this.
Yes,
matter.
therefore, let it come up on 28th of 28th of November. The interim order shall continue till next week.
What they are suggesting that your lordship is then to be releasing because lordship doesn't have enough.
Yes,
Then when we present partner, then your lordship release it thereafter. We don't know, let me be partner, I don't know subject to what my done.
no, it may not, because it is very long. 28th November is far away. Keeping matter part so long may not be proper. So let it come up on. Interim order shall continue.
Yes. That's
When-
okay, matter, fine. Let, I know, if it will be on 28th, and if his partner is not, then it will be released automatically.
No, part. it may not be,
Because I tell you very frankly.
otherwise, had it been a shorter date,
It's not a choice of mine, and my age is not a choice. I do.
no, I would have loved to
Yes,
hear the matter because this matter is new matter involving a new subject. But because the 28th November is far away and there is no guarantee that I would be again posted here during those days. So it may not be proper to keep it part
Super fine.
28th November.
Interim order to voting is.
Yes, interim order shall continue.
Voting is.
No issue. Show presence of all the councils.
My lord, that dustbin has to be given. There, dustbin we have got that already.
Yes, learned senior counsel for the
Services completed.
learned senior counsel for the petitioner in WPC 6 in WPC 6 this order would be petitioner submits that the petitioner has furnished an affidavit to the effect that the notice issued to the newly implemented respondent number 6, 5 and 6 have been served through dusty mode. Stop. Considering the affidavit submitted by the petitioner, the service on respondent newly implemented respondent number 5 and 6 is deemed to be the notices is deemed to be duly served. Show presence of all other councils.
But 17 would have not been decided by anyone. Neither way the Supreme Court.
Yes,
17 was clear.
that the authorized
No, authority seizing.
seizing authority.
Authorized, it is in one of the paragraph in Vijay Malangar case. But so far the authority seizing, that's not clearly has been decided by the honorable ethics. The
Yeah.
authority seizing. Whether it should be assistant director or superior.
His hierarchy.
Yes.
That is the main plea you have
Yes,
taken.
that's what I asked. Otherwise, the situation will become complex. There are four places where search has been Caesar search has been directed by the deputy director. So he actually becomes our interpretation, he becomes the seizing authority. Because authority seized, because there will be four different assistant director will be sent to four places. So whether this four assistant director will file application before the adjudicating authority.
Yes.
So this is the area where my interpretation is required. 17.4. 17.2, I think one of the paragraph of the episode makes it very clear what is happening. Very, very clear, 17. This is the authority who has been authorized. And 48, the authorities have also been explained who are the authorities. So it's a matter of interpretation in 17.4. Whether he has what is the indication. If it is assistant director, not by the deputy director, or our case, then he doesn't have a judicial even to find this. That is why initially there was some prima facie in the interim order was passed, subject to hearing further of this case. I have features in so many high courts, other high court passed. This is expect not to say.
17 for okay. Let us
Very
see.
interesting, this particular. With you on this. Thank you. Sorry, let me raise to I told him that please take rest, the body is important.
If I may, so am I audible now, my lord?
Yes, Mr. Borgohain.
Am I audible now, my lord?
Yes, yes.
Your lordship, I seek an indulgence. I believe I have been ambushed by NIA, both in the principal bench and the Kohima bench. What happened, your lordship? This matter was fixed. And suddenly the other matter, with respect to the same petitioner, has been listed before the court number 4 today regarding my bail hearing, final hearing. So in view of same, I cannot address two courts simultaneously. And
Okay.
secondly, my lord, there is a certain documents have to be filed in this matter. Since the petitioner at this point, he became his role has been changed now. So I was unable to get his notarized those documents. So my lord, I may seek in 1 week's time. In the meantime, I will file it. And
You are submitting in item number 13 and 14.
13 and 14, my lord. Because today there is one division bench matter is pending, is listed before court number 4. Final hearing for the bail application. The NIA challenged my bail. So it is very difficult for me to appear in both the courts, my lord.
Okay. Yes, Mr. I forgot your name.
Satyan, senior.
Satyanarayan. Yes, what is your submission?
My submission, lordship, it is a long pending, since from 2018, it is
No,
take.
but his situation is, he is engaged in.
Last time also he has take adjournment on the ground of he want to file some application. Today he has not filed any application, my lordship, in that regard. Again, submitting same thing, you want to file some application or affidavit.
May I clarify it, your lordship? What my learned friend is trying to ventilate is that earlier adjournment was being sought on the ground of some filing of document. It is not that way, your lordship. What happened? The matter pertains to interpretation of section 39 and 40 of the Unlawful Activities Act. Recently, the Honorable Apex Court in unidentical matters, they have interpreted those provisions, and my facts and circumstances get changes. So I apprised this Honorable Court. The Honorable Court granted the leave that you file the applications. But the thing is that the petitioner, who was at that point of time a government servant, now he retired, he resigned from the service and he joined in the mainstream, and now he's a sitting MLA. So I have asked him to come down with papers and all. So I need an indulgence of 2 days. They are going to give the signatures and all, and I will file it. And today, as far as my appearance in coming down to Kohima was concerned, I would have. But suddenly, the matter has been fixed before the division bench, where they have challenged the grant of bail, which has been granted to me by the trial court. So that is a peculiarity, circumstances which restrict me from appearing before your court, before your lordship physically.
When do you want it?
30th of October. Someone has mentioned.
30th of October.
30th of October.
30th of October will be difficult for me. I won't be available, my lord. Immediately after the vacation, my lord. After the vacation. 30th of October, it will be difficult for me.
You want a fixed date? When would be convenient for you? You suggest a date, or we will fix it after vacation.
Which date is convenient? I will come on that day and dispose of landlords.
Pardon, I am not able to hear.
Again, he has to be taking a adjournment.
The NIA council wants a fixed date. He is also not from Kohima. You are also not.
I am from Gauhati.
Fix on a particular date, your lordship. So
You suggested date.
your lordship, can it be done in November? Can it be done, to be very much more practical, my lord, can it be done on 16th of November, so that we get Thursday and Friday? Saturday.
Heard Mr. Your initials are Mr. What Borgohain?
Siddharth Borgohain.
Mr. S. Borgohain, learned counsel for the respondent. Learned counsel for the petitioner. Also heard Mr. Satyanarayan, learned senior public prosecutor, NIA, for respondent number 1 and 2. Learned counsel for the case for an adjournment on the ground that he has to appear before division bench of this court today itself in a connected meter.
Criminal Appeal 129 of 2018.
Criminal Appeal 129/2018. And praised for listing this matter after a week. On the other hand, Mr. Satyanarayan, senior PP, NIA, submits that it may not be possible for him to conduct this matter after a week, and prays for listing this matter on after 30th of October. Hearing learned counsel for both the sides, the prayer for adjournment is allowed, and with the consent of learned counsel for both the sides, this case is fixed on 16th of November. 16 November.
My lord, 16th of November, my lord, interim order to continue till next day.
The interim order shall continue till next day.
Obliged, Lord.
For admission, item number 8.
They have gone through.
Yes, yes.
What is the statutory period?
It has to be 68. But you, my lord, absolutely right.
He is already behind the bar for,
I mean, we are allowed to raise the.
yes,
2017. 15,
Rakesh Paul.
yes, Rakesh Kumar.
Okay. For how, when you were arrested?
Was arrested on the 29th of July 2023.
And what was the quantity of contraband which was seized? What was seized? No, just what was recovered from your possession?
There should be 85 forms of consider.
85 bottles. But 85 bottles is how much? That is wrongly. 85 bottles is not intermediate. How much total quantity comes? 8.5 liters.
Yes, it must be, but the amount of protein in 100 ml, 100 ml bottle of plastic is only needs to 0.17%. So
Where is the FSL report?
FSL report is not there, not just on the, it is on the
Label.
it's on the label.
Where you show me?
I do not have that, but not just.
No, some document to show that what was the quantity of codeine. Because to be treated as a manufactured drug under NDPS Act, the quantity of codeine should be more than 100 mg per dose, per 100 mg. So if FSL report is there, whether FSL report is there, you have produced the case diary.
Lordship, Lordship is already before your Lordship. It's sent for expert opinions, Lordship.
So that will be a question of then.
Because then it is wrongly registered under section 22B. It appears that quantity is of commercial quantity, though wrong quoting of section is there. So this Rakesh Pal will not help you.
I have a slightly different understanding of the in regard to FCR, which contains just a minuscule amount of
Yes, yes.
0.17. If we can
You show it if it is 0.17.
I can, my lord, I can only at this point, I can only produce the overall FCR, and we can. I have checked, recently I have checked it, but they are not over here.
Now, what is your submission?
So my submission is that on
Because
basis of-
today the bail which we have granted in the morning, today one bail was granted in Kafsar of codeine matter. You go through that judgment, which is delivered today. That is on that line, that the quantity of codeine is less than 100 mg per dose. Therefore, at this stage, it is difficult to ascertain whether it is a manufactured drug or not. So you go through that and make submission again.
However, if that is not the observation of the doctor, allow me to just contest the application on their research, because the
You are ready?
Yes, sir.
Okay, okay. Yes. Yeah.
facts of it is.
Soshi Temjen, your name,
No, to show
Toshio Longkumar. Yes.
the brief facts is that the accused, but my lord, at the outset, the applicant is the relative of the accused. Relatives of this. My lord, the accused was apprehended at BSF Camp area while traveling back from Timor on the basis of a surprise checking done by the mobile unit of EEF of Timor.
On 29/7.
Yes, was
Okay.
on the basis of a surprise checking. So I'm coming to that question, but then just let me just lay out the facts before we go. So he and his friend was traveling in and out of and on the basis of a surprise taking, the police personnel, they stopped the vehicle and they checked the boot space of the vehicle. And while rummaging through the boot space of the vehicle, 85 bottles of gas syrup was allegedly found. And accused as well as his friend, who is the owner of the vehicle and the driver, they were taken to the for investigation. And on 30th, on 30th, formal arrest memo was issued to the accused. While there's no at this point the accused as well as the do not know on what basis the owner of the vehicle and the driver was released and the auto of the vehicle was also released. It is a but even in the FIR, if I may take you to the FIR number, the SO FIR, which is at page 14. That would be at page 15. Here in the sum of the FIR also, only the name of the accused. We cannot read the FIR number.
Yes.
Obviously, in terms of yes, some of the FIR. In reference to the above stated subject, I would like to report your system authority on 29/07/2023 at around 8:30 p.m. while NUDEF, Kohima was conducting surprise taking one vehicle of the very number second such was intercepted below BSF camp area, and upon checking, recovered 185 members of gas syrup and then 14. After which one person named was apprehended for being.
Is it 85 or 185?
85, but if we continue, after which one person named Robin Jimo was apprehended for being in possession of 85 members of gas syrup. This is for your information and necessary activities. And page 60 is the property considered as figure.
Yes.
Here at page number 17, circumstances or grounds for seizure containing property. And page 18 is the arrest. Here, my lord, I would like to take you now to page number 19. So, whether the arrested person has per observation. Before that, my lord, Whether the arrested person as per observation and known to its purpose. Number A, is dangerous, no. Number B, previously some illegal, no. Is generally armed, no. Is non-distant criminal, no. Is recidivistic, no. Is likely to some fail, no. If released on fail, likely to be found of that independent or no. This is a observation of the risk during the arrest of the accused. So, my lord. The applicant hearing approached special judge Kohima for review hearings. And by order dated 4/9/23, rejected the bail. Lord, I've already sent page number 24. This is related on what ground it was rejected and the law is just 21. The last paragraph. Heard both the learning councils perused the case report along with the case study. On going through the record, it appears that the accused person was arrested on 29/07/2023 for seizure of 85 members of South Syria. There is prima facie material against the accused, and the period of investigation is still not known. This court is in line with the prosecution to give enough opportunity to investigation and investigating exits for investigation. With the aforementioned view, the prayer of the petitioner is the accused from bail stands rejected. The only prompt rejection of bail was to give further time to the prosecution or the investigation authority for further investigation. My lord, even after the lapse of more than 70+ days, there is no progress to the investigation. That is one point, my lord. And my lord, I have 3 points on which I'm asking for bail at this point. The 3 conditions, that is under section 7, that there has to be a reasonable ground to believe that the accused is not guilty. Second is, if that is right, second is the accused is not likely to stand bail or to tamper with the evidence. So on the basis of that, Lordship, I just want to lay out praise on this one that the checking of the whether that was authorized when there is some question, whether the section 42 of the Case Act was complied with. Second is, since the driver and the owner has been released, and on what grounds at this point the accused and the did not know. So, my lord, the investigation seems to have we have some suspicion on the investigation or the agency. Why? Because my lord, it is settled principle that when the evidences are against the accused, they cannot detain one and they cannot be decided without proper counsel, without the legal report. And second is, my lord, it is also a settled principle that a vehicle once seized cannot be released without legal report. At this point, since it is only an investigation period, my lord, they cannot have 2 different justices for deciding whether someone should be released or someone should be detained. And it has been and it is the plea of the accused that the Gauhati does not belong to him. He was just accompanying his friend who went on to Dimapur to book slaughter pigs for his wedding. And on the way back from Dimapur to Singapore, they were insane. So that is
How it came in your position, Kafsero?
I was not in conscious position of my lord. I did not know it was there in the car itself. That is our stand. I was only in the passenger seat, my lord. So I cannot be held to be in conscious possession of the castle. And my lord, like I raised earlier, the checking was not allowed to be witnessed by the driver as well as the accused. The police, there is apprehension that there is foul play here, but my lord, that will be subject for the trial holder to raise a question. My lord, it is also it is also, my lord, is very well aware of the fact that we custodial investigation is not necessary. Just because. it is
No,
always-
here- No other submissions. You have to only cross the embargo of 37.
Yes.
You have to just show that 37 is not applicable.
Yes, but my lord, on the basis of all of my submissions, the embargo, put upon by, Section 7, will not apply. I mean, it's fine. Or will not apply to the activities of my and the accused individuals on their, because, my lord, first of all, the accused was not in conscious possession. Second, my lord, there is apprehension of, all day. Inside of the institution authority. And third, my lord, when it says that evidences are against the accused and its co-accused, they cannot be put in your states. And then, my lord, even the FIR did not mention anything about the travel. And then, see, well, just, lastly, there's zero apprehension that the accused did not compare with John Taylor. He is not a member of any gang. There's no criminal incident against him. And my lord, the applicant Harry, who is a government employee, he is ready to stand surety for the accused international. And at this point, since the ongoing the investigation, there is no progress to the investigation, even after a lapse of 70+ old days.
Yes,
Further detaining the accused will be.
yes, Mr. Angami.
Lordship,
You have case diary?
Lordship, I've already submitted last Thursday. Lordship. It's just 3 or 4 page sheets on the Lordship.
Okay. No, FSL report is not there.
Oh, it's a way, it's sent for expert opinion. That's the report says, Lordship. So investigation is still going on, Lordship. So this time, if accused is not released on bail, because there's a that is not material so far. Materials against permanent facing materials against the accused, Lordship.
Okay, I'll go through it.
Lordship.
No, regarding whenever you seize codeine,
Lordship.
there is a notification of the government of India under notification wherein there is an entry 35 which mentions that how much codeine is exempted,
Lordship.
how much quantity of codeine is exempted. So if somebody is apprehended for possessing codeine, you have to prima facie prove that this codeine content of the seized contraband is beyond the exemption limit.
Lordship.
Some material has to be there
Lordship.
so as to detain him. If it is beyond the exemption limit, then bar of 37 will be applicable. If it is not beyond the exemption limit, then it may not be, then his length of detention would be looked into. I'll go through the case diary.
Lordship.
Heard Mr. Toshi.
My lord, if I may allow the places the authority to assist. My lord,
Yes,
Yes, I'll just, I won't read, I'll just speak the citation.
regarding,
Regarding on the question of on the merit of the application, not on.
okay,
First, 2011 is. 2011 is page 784.
784. para 15, and then
2022 SEC 118.
2022 SCC.
118. Para 25 to 27.
25, 27, and then
2018 3 SEC. 2, 3, 4. 2000 next is 2012, 1 is 16, that's in the 14. 21 to 27. Just this would not bind my lord come to a conclusion, but then just for reference, this is a judgment of 2022, this is not 994, and the facts is also quite significant.
give copy to me. Heard Mr. Toshi O. Longkumer, Learned Counsel for the petitioner. Also heard Mr. K.V. Angami, Learned Public Prosecutor, Nagaland. Let this matter be listed for delivery of orders tomorrow. That is on
17.
18, 17,
17.
10. Tomorrow I'll pass on.
Lordship, just for one more submit, in the event, it has to fall under 60 days period, Lordship. My submission is that there's no application for releasing the bail, the accused on default.
That
No,
question
but this is not a case under 60 days.
Lordship. Okay, Lordship.
Total
Just
80.
in case, Lordship. Just in case.
that question has also been answered by Rakesh Kumar versus Seventeen.
No, this bail petition
Lordship.
may be treated
Yes,
as a
Lordship. Lordship.
bail for default bail,
Lordship.
but it does not appear to be a case for
Lordship. Lordship.
case falling within that default bail category, because the quantity of contraband is more than.
This actually on the question of costs here, there is this particular question whether it will come under intermediary quantity or commercial quantity regarding only costs here, which has minuscule quantity of within the High Court policy also have negative consideration. Plus again, subsequently in 2022,
You have cited Iqbal Singh. You have relied upon Iqbal Singh.
No. I'm just informing this question. This question of whether it should be intermediary or commercial, this has to be again considered by the Supreme Court again. If not, there is quite some technical difficulty arises. When I was researching on the question posed by my lord also, I found out that this question has to be set to rest on the future. Otherwise, no.
Okay, tomorrow.
For admission, item number 9.
This matter relates to regularization of the services of the pensioners. It will require exhaustive hearing.
Exhaustive hearing.
Yes. And considering the circumstances. It should not be completed because Act 2, project has fixed that the particle matter.
Okay.
That is also a fixed matter. And
So let it come up some other day.
let it be after the vacation.
Who is appearing?
Mr. Mua and Chen, who is representing the state, is also on this important program. So, due to multiple reasons.
No, he may, Mr. Angami may. We are not going ahead with hearing.
Lordship.
We will only defer it after a vacation.
Lordship.
Heard Mr. C.T. Zamir, London. Senior counsel assisted by T. Zamir. Toshi Jamir, Learned Counsel for the petitioner. also heard Mr. KV Angami, who appears on behalf of Mo Chen, Learned Senior Government Council. On request of Learned Senior Council for the petitioner, that this matter may require an exhaustive hearing. This matter is adjourned and fixed on, you want to fix it or after vacation? This matter is adjourned and may be adjourned for today and may be listed after 4 weeks.
For admission, item number 2.
After something. Item number? Number 2. You are for in item number 2?
Yes, Lordship.
Okay.
Lordship, in this case, the prayer is limited, Lordship, to the extent of defreezing the account of the petitioner's, Lordship. I have approached the land trial court on 2 occasions, Lordship. It was rejected.
Who is appearing for NIA?
Lordship,
Mr.
NI council is also here, as well as the state council, Lordship. PP.
Satyanarayan.
My lordship, this petition is filed by the petitioner seeking decreasing of the accounts and releasing of the 95,000 of amount.
Seeking
Defreezing
defreezing of,
bank accounts
okay.
and releasing of 99,000 in favor on Jimma bond balance. My submission, my lordship, subject to condition not to transferring of this bank accounts any uses for any transaction, and anyone has deposit any use amounts in their account, they immediately intimate to NIA for concern.
Otherwise, you don't have objection to his.
No. Our investigation is going on. Therefore, we suspected that Avala is going on here is that someone has demand someone and give someone account, then immediately deposit some use amount, immediately withdraw and give it to the uses. This is the trend is going on. Therefore, avoiding this situation, my submission, my lordship, not to share their accounts to any uses. And if anyone
Not to share their account to
any uses underground outfits.
any
Members.
underground.
Underground members, my lordship. That is the NSNK, you are who are the extortionists.
No, how this may be ensured?
They have to.
They have a bank account. The petitioner has a bank account,
Please,
Lordship.
which can be operated only by the petitioner.
please,
Lordship.
my lordship.
So after taking out money, where he gives money, how it can be monitored?
My lordship, what happens? They share the accounts, someone has to deposit their accounts. Immediately, these persons are withdrawn and whatever the cash they have to be given to the users. That process is going on.
Or somebody else deposit money in their account, they withdraw it and hand it over to underground.
Therefore, avoid
So his account is being used by the underground agency.
agencies, my lordship. Subject to condition, my lordship.
Now, what condition I can impose?
And not to share their accounts to any uses.
Not to share.
Not to share their account to any uses for transferring of the amounts.
No,
illegal.
otherwise the account cannot be shared. But after he withdraws the money,
It withdraws the money. So one more my submission, my lordship. If any amount above 20,000 deposited any other unknown person their account, they immediately intimate to the NIA.
okay.
Therefore, then we have to investigate with that.
That in the said account, if any deposit is made more than
20,000.
more than 20,000, it has to be
Immediately
intimated to
intimated to
investigative authority. That condition you are agreeable.
Lordship, I can comply that, Lordship. I can comply. Lordship, even otherwise, the NIA has already filed the charge sheet, Lordship, in the year 2020.
Accused person, my lordship, we were in the involved, one is the NSCN Kedar, one is the Avala Channel, Jai Kishan Sharma, and also they are involved in other case, which is the killed by 11 person, one MLA and 11 in Arunachal Pradesh, my lordship. Therefore, we filed already in both cases charge sheet. They are facing trial in there and here also, my lordship. That two accused person role is different from this person, my lordship. Therefore, at the filing of charge sheet, we are not filed, but we are praised for the Honorable Pressure Court for continuing further investigation against these two of them. Accordingly, Special NIA Court allows us to further investigation purpose of this financial transaction.
Further investigation is going on.
Please, my lordship.
Going on.
Going on.
Against
Against
the
these two petitioners.
Okay. Yes, Mr. Imchin.
Lordship, the charge sheet was filed in the year 2020.
Jamir.
Lordship.
Yes.
If your Lordship may kindly perused only the relevant part of the charge sheet, Lordship will find the charge sheet at page 31, annexure 5, Lordship. This charge sheet was filed in the year 2020, Lordship, and it has been pending for quite some time, Lordship. There is an observation made in the charge sheet that further investigation is required for the present petitioner's Lordship. If your Lordship got it, page 31 of my petition, Lordship.
Page 31.
Yes, Lordship.
It is the charge sheet.
Yes, sir, Lordship. This is the charge sheet dated 14th of February 2020, Lordship, in NIA case number RC 10th of 2019, NIA Gauhati, dated 17th of September 2019, Lordship. If your Lordship may kindly allow me to take your Lordship to paragraph page 39, Lordship. I'll just read out some relevant paragraphs, Lordship. After that, I'll make my submissions, Lordship. If your Lordship allows, Lordship.
Yes.
Page 39, if your Lordship got 17.11, Lordship, paragraph 17.11. Lordship, what has happened, Lordship? 4 accused persons, they were arrested, including the petitioner's, Lordship. They are not involved, directly or indirectly involved in the alleged offense, Lordship. May I read it, Lordship?
Yes.
17.11. Investigation further revealed that the seized materials recovered from the possession of Lakin, this is the main accused person, Lordship, Mr. So-and-so, and Jai Kishan Sharma. These are the two main accused persons, Lordship, in this case, were deposited in the court, Malkhana, Dimapur, by police before handing over the case documents to NIA. Mobile phones in respect of Lakin, so-and-so, and Wangling Tangjang were taken over from court Malkhana to sent to so-and-so, New Delhi, for forensic examination and expert opinion, the reply of which is still awaited. The materials seized from the accused, Jai Kishan Sharma, this is the second main accused person, Lordship, were forwarded to NIA Special Court, Idanagar, in connection with NIA case number RC3 of 2019. There is another case connected with this, Lordship, for the two main accused persons, Lordship, Jai Kishan Sharma, Lordship, and Lakin
Jai
Miswal.
Kishan, who is the petitioner in this case?
He is not in petitioner, they are the accused A1 and A2. Lordship.
Okay.
May I continue, Lordship? 70.12.
Yes.
Case amounting rupees 11,45,460 seized from the possession of 4 accused persons, which were kept in the court Malkhana, Dimapur, and taken over by NIA on 24th October 2019 as per the order of Learned Special NIA Court, Dimapur. So those cases were taken over by the Special Court NIA Court, Dimapur, Lordship. If your Lordship may kindly allow me to take your Lordship to paragraph 17.14, that is the next page, page 40, Lordship. This is with regard to the present petitioner's, Lordship. 17.14.
Yes.
Investigation revealed that both the accused Samwing and Wang Lik, Lordship, were in touch with each other.
These are the 2 petitioners.
Yes, Lordship, these are the 2 petitioners. They were lodged at Hotel Saramati, Dimapur on 20 August 2019. CDR analysis of the mobile phone numbers recovered from the possessions of both the accused, that is so-and-so, and Wang Lik, so-and-so, has established that they were in telephonic association with each other before the arrival at Dimapur. Accused Samwing, though was in touch with accused Lakin Mashangwa, that is the main accused person. Before the arrest, it was found that he was not directly involved in the instant case of extortion and terror funding, Lordship. This is very important. However, his role in other activities of terrorist group of NSN-IM cannot be ruled out, for which further investigation is required to establish his role. This is the observation. 17.15, investigation revealed that accused Wang Ling, this is also one of the petitioners, Lordship, was accompanying accused Samwing for the purpose of purchasing of some materials for the business of his wife at Dimapur, for which he came to Dimapur. Investigation revealed that he was not associated with either accused Lakin Meshongwa or accused Jai Kishan Sharma. These are the two accused persons, main accused persons. However, further investigation is required to establish his role in the instant case. That is the only observation, Lordship. They have stated that they are not directly involved with the main accused persons. And RC3, which is referred in this charge sheet, is with regard to the killing of the MLA Lordship at Arunachal Lordship. So they are not directly or indirectly involved in that case, Lordship. If a Lordship may kindly allow me to turn your Lordship to page 42, Lordship, page 42. Para 21 would relate pertaining to charge, Lordship. If your Lordship got it. Page 42, 21 charge. Serial number 3, the third point, that is with regard to the first petitioner's, Lordship. Samwing at the rate so permanent address of Kaimai POPS Konsa district, Tirap, Arunachal Pradesh. Now, offenses of which prosecution is recommended, Lordship, on the right side of the column, Lordship. No prosecution at this stage. Further investigation to be continued. Nothing has been charged, Lordship. And with regard to the second petitioner, the serial number 4, Lordship, this is Wang Lik, Lordship. He is also a resident of Tirap district, Lordship, Arunachal, and the same observation, no prosecution at this stage, further investigation to be continued. This was observed in the year 2020, Lordship, and we are in October 2023, Lordship. Nothing has been established against the present petitioner's, Lordship. Now, what has happened, Lordship? I'm aggrieved by these 2 orders. If a Lordship may kindly allow me to check 2 orders where the learned special court has rejected my prayer, Lordship. Page 50. Annexure 7, page 50, Lordship. 50, Lordship.
Yes.
This is the order passed in IA number 171 of 2021, Lordship. Petitioners, it is a common petition filed by the court of petitioners, Lordship. The order starts from the next page, page 51, Lordship.
Yes.
May I take your Lordship only to the relevant paragraph, Lordship? Page 53, paragraph 9. Paragraph 9, only the observation of the learned special court, Lordship. Paragraph 9, Lordship. May I read it, Lordship?
Yes.
This court has considered the submissions made by the parties.
Para?
Para 9, Lordship. Lordship will find it page 53.
Yes.
Para 9, the bottom, Lordship. This court has considered the submissions made by the parties. It is observed from the records that the case has been at the charge framing stage since March 2020. This is important, Lordship. And further progress could not be made due to the lockdown which was imposed in the month of March 2020. And due to the same reason in 2021, also the framing of charges yet to be taken up. The charge sheet was filed on 14 February 2020 against accused Lakin Mashangwa and Jai Kishan Sharma. These are the 2 accused persons, Lordship. And charge sheet has not been filed against the 2 appellants herein, the present petitioner's, Lordship. However, there's also a fact that due to the lockdown in Nagaland and Arunachal Pradesh, the movement of the investigating agency personnel has been restricted and the transactions in SBI account number. These are the 2 account numbers, Lordship, which we are concerned here, Lordship, and their linkage in terror funding needs further inquiries. This court is therefore not inclined to allow the application at this stage, Lordship. That's the observation and how my application was rejected, Lordship. Subsequently, I have also approached before the same special judge NIA Dimapur, Lordship. Lordship will find the subsequent order at page 55, the next page, Lordship. This order is passed in IA number 371 of 2021, Lordship. This is order dated 5th April 2022, Lordship. May I read from the relevant paragraph, Lordship, to save this precious time of this honorable court, Lordship?
Yes.
Page 56, the last two paragraphs, Lordship, with regard to mobile phones.
Yes.
With regard to mobile phones seized from the possession of the accused applicants, it is submitted by the learned PP for the NIA that the same were sent to CART in New Delhi for forensic examination and expert opinion report, and that the reply is still awaited. As such, the seized mobile phones also cannot be released at this stage. Coming to the seized cash amounting to rupees 99,000 and rupees 360, which were recovered from the possession of the accused applicants, it is seen that the accused applicants are being investigated for their linkage and the terror funding. As such, I'm not inclined to consider for their release at this stage, and the same will be considered only if the investigation against the accused applicant is completed, Lordship. It continues from the next page, Lordship. Para 4. Now, coming to the other items which the accused applicants are praying for their release, namely the checkbook, Aadhaar card, driving license, ATM card, and electoral identity card, which are mostly of the nature of personal items. A result of the report would show that the NIA did not make any specific objection for the release of the aforesaid items. As such, I'm inclined to release the aforesaid seized items on Zima. 5. Accordingly, in view of the aforesaid, the instant application is partly allowed, and the SBI checkbook so-and-so, which was seized from the possession of the accused applicants, namely so-and-so, are hereby released on Zima and handed over into the custody on executing a Zima bond for an amount of rupees 10,000 each, which without surety, Lordship. Now, those items were released by this order. However, the freezing of the account, it was rejected, Lordship.
And the cash amount of 99,000.
Yeah, Lordship, along with that, Lordship. Even the cage was not released, Lordship. 99,000 and
Not
360.
released.
Just with the custody of court, my lords.
It is.
That to be subject to condition, my lords, to cooperating investigation that money.
Okay. What conditions?
We may cooperate the investigation as an inquiry about the money regarding, we may answer that part, my lordship. It is the two part of prayer, my lords. One is the defreezing of account. Second part of prayer is the releasing of amount of 99,000 and two amounts are.
Heard Mr. Moazamir. Anything, any submission?
Lordship.
Heard Mr. Moazamir, learned counsel for the petitioners. Also heard Mr. Satyanarayan,
Senior PPNI.
Senior PPNI. This petition under section 482 of the Code of Criminal Procedure.
My lordship, respond number 1.
I think.
Oh,
Lordship, I'm just a formal party, but for state respondent, Lordship.
okay. Stenographer. Where is the FIR?
What you will find it, page 24, Lordship.
The allegation in the FIR was gist is
Lordship, an amount of rupees 11,45,460. It was seized from four alleged accused persons, including the present petitioners. That was the allegation, Lordship.
okay. And seized and it is suspected to be for terror funding.
Lordship, that was the allegation in the FIR.
Whether that was the allegation
Yes, Lordship.
or it is seized as treating it to be, it was suspected to be a money, extorted money.
Extorted, Lordship, 384 is also mentioned, Lordship, IPC 384, Lordship.
Heard Mr. Moazamir, learned counsel for the petitioner. Also heard Mr. Satyanarayan, learned senior public prosecutor NIA. This application under section 482 of the Code of Criminal Procedure, 1973, read with section 459 of the said court has been filed by the petitioners, namely Shri Samging Wangsu and Shri Wanglik Tangjeng, impugning the which order you are impugning? Impugning the
The first order is 16 July
order
2021.
dated 16 July 2021. Passed by the Court of Learned Special Judge NIA Dimapur in IA within bracket Jimma application number 171/21 arising out of RC-10 of 2019. Whereby the prayer for defreezing the SBI account number 1138754368 of Mr. Samging Wangsu. In which bank it is, this account is there?
SBI Lordship, Tirap District Arunachal Lordship.
Mm.
The details are given here, Lordship.
Both accounts are in Tira.
Lordship, both the accounts, Lordship.
Or in different banks.
Same, Lordship.
And SBI account number 372483511034 of Wanglik Tangjang in the SBI Khonsa branch, Tirap, Arunachal Pradesh was rejected. The petitioner has also prayed for release of an amount of rupees 99,000 of Shri Samging Wangsu within bracket petitioner number 1 and to release and prayer for release of amount of rupees 360 of Shri Wanglik Tangjen petitioner number 2, which was seized in connection with NIA case number 10/
May not say it originally seized in Dimapur case. Later on, cases transferred to NIA.
which was originally seized in connection with which case? Presently, it is seized.
RC Lordship. It is RC.
RC
10
is
of
the
2019.
later NIA is.
But presently, it is seized in
See in the NIA custody, court custody.
Seized earlier in connection with
Dimapur East Police Station registered FIR number 0204/2019.
Dimapur. Please repeat.
Dimapur East Police Station, Dimapur, FIR number 0204/2019.
And presently seized in connection with RC 10/2019 NIA Gauhati. Stop.
NIA in case not seized, amount as it is transferred.
Transferred. Presently transferred in connection with, instead of seized, presently transferred in connection with NIA case number so and so. Learned counsel for the petitioners has submitted that though the investigation of NIA case number 10
RC 10 of 2019.
RC 10/2019
Lordship.
2019 has already been completed. And where is the charge sheet? At page?
Page 31 Lordship.
And charge sheet in this regard
Investigation complete against two accused, my lordship, against these petitioners are.
His submission.
Please.
Investigation has been completed. And charge sheet has already been laid by charge sheet dated 14/2/2020. It is further submitted that in which you have shown some column in the charge sheet where
Page 42, Lordship.
it has also been submitted by learned counsel for the petitioner that in column number 21 of the charge sheet, it has been specifically mentioned that the charge sheet has been laid against main accused, mainly Lakin, Mash, Hangwa, alias Wangking, Lowang, alias David, and Jaikishan Sharma, alias Jackson. However, no prosecution was recommended against the present petitioners at the stage of filing the charge sheet, and it was stated in the charge sheet that further investigation is to be continued against the present petitioner. However, in spite of the filing of the charge sheet way back in the year 2020, the prayer for defreezing of the bank accounts stated herein above, which were earlier freezed in connection with the investigation of the said cases, was rejected by learned trial court only on the ground that the linkage of the aforesaid SBI accounts in terror funding needs further inquiry. Stop. Learned counsel for the petitioner has submitted that after laying of the charge sheet, sufficient time has been lapsed
Lordship.
and the petitioner is deprived of using the said bank accounts due to freezing of the said bank accounts in connection with the aforesaid investigation. Stop. On this, learned senior public prosecutor, NIA has submitted that though charge sheet has not been laid against the present petitioners, however, the investigation is going on against the present petitioner regarding their linkage with the aforesaid case in which the charge sheet has been laid. However, learned senior public prosecutor fairly submits that at this stage of investigation, the continued freezing of the aforesaid bank account may not be required if and same may be defreezed subject to certain conditions like the petition, the learned special public prosecutor, senior public prosecutor suggested that the petitioner's accounts may be defreezed subject to condition that he may be directed to intimate the investigating officer as and when an amount of rupees 20,000 or more is debited or credited from the said accounts. Anything else?
And also he should not be give it his account number to any using people for transferring amount, my lordship.
Then how will he?
Sometimes this trend is going on, my lordship. This is here, extraction is expected, someone demand, the demand is given by someone and again they give it to the one number.
No, blanket order, he will continue to that. limit.
NSNM mentioned, my lordship, other NSNM cadres, underground cadres.
Lordship,
No, you have not yet found anything against him.
exactly, Lordship.
So how this can be imposed?
And I'm
One-
in no way connected with any of those factions, Lordship.
Because you have, till now, you have not found that whether he has,
Some
it
CDR.
is only a suspicion.
Suspicion, my lordship, we have some CDR calls with some other, therefore it is under progress for verification, my
You
lordship.
continue your investigation,
Please.
he will cooperate.
Please,
If you require, the limit may be lowered,
please.
or 20,000 is okay.
My lordship, let.
And regarding the 90,000 which has been,
That subject to condition as and when it is required for investigation trial purpose, they may be produced before the court also. It is one of the part of the seizure, my lordship.
what they will produce.
Amount are subject to condition. Otherwise, my lordship, that seizure, it is one of the, it means other accused persons also.
No, you want same notes,
Maybe otherwise he has to say, suppose as and when, suppose.
that in that manner, he would be again debarred from using that
Exactly, Lord.
99,000.
Exactly.
If you later on find out that, if later on it is found
Please,
that this amount is an extorted,
extracted money.
he will again
He will
deposit.
again deposit.
Lordship, I'm ready to cooperate with the investigating agency, Lordship.
So learned senior public prosecutor also submits that the amount seized, amount of rupees 90,000 and rupees
99,000.
99,000 and rupees 360, which was seized from the present petitioner, may also be given in custody of the present petitioners, subject to certain conditions. Stop. Considering the submissions made by learned counsel for both the sides and considering the facts that at this stage, when the charge sheet against the FIR in which the allegations were made against the present petitioner has already been laid almost 3 years ago. And till now, nothing has been, till now, no incriminating materials have been submitted. No incriminating materials against the present petitioners could be shown by the investigating authorities. Continued freezing of the SBI account numbers of the present petitioners may not be justified for any further investigation in this regard. Therefore, it is directed that the SBI account number 1138-75-50-75-43-648 belonging to Samsing Wangsu and SBI account number 372-483-510-34 belonging to Wanging Tangchan is hereby defreezed. However, a condition is imposed on the petitioners that whenever there is a transaction to the said accounts above rupees 20,000.
Lordship, if the amount can be raised, Lordship, 20,000.
20,000
Okay.
above minutes.
No, 20,000 and above.
Oh.
If
20,000.
it can be fixed at 50, Lordship, 50,000. Lordship.
It is for the NI,
May lordship, sometimes they may be deposit 10 lakhs also. Therefore, may.
20,000 and above.
Above, any amount.
We will fix a time,
Lordship.
20,000 and above. Same share during next, how much time you will require?
May lordship, can you fix 1 year at least?
Lordship, we have taken already 3 years to complete, Lordship. Nothing has been found, Lordship.
It cannot be for unlimited period.
Exactly, Lordship.
See, otherwise 10 months, my lordship.
Okay, 1 year. You for the period of next 1 year or till the investigation of NI case number 10/, RC case number 10/,
2019 no.
2009, further investigation of RC case number 10/2000 continues whichever is earlier. The petitioner shall intimate such transaction to the investigating officer of the said case.
Hmm.
Similarly, the court of, who will release this amount?
It is in the custody of the court, my lordship. They file and they may execute in Zimbabwe, the amount may be released.
Special Judge NIA Lordship.
Similarly, for this aforesaid reasons, the amount of rupees 99,000, which is seized in connection with the aforesaid case, is directed to be released to the petitioner number 1, Samsing Wangfu, on furnishing a bond of rupees 99,000 for production of the same as and when so required by learned session judge.
Lordship.
Learned special and I
As learned special judge NIA. And the amount of rupees 360 be also be released to the petitioner number 2, Shri Wanglik Tangjang, on furnishing a bond of rupees 360 for producing the said amount as and when so required by the learned special judge. In connection with the in which case this amount was seized? RC 10.
Originally in Dimapur case, later transferred to RC case.
So no, in connection with the is not required. Stop. With this observation,
Yes.
this criminal.
What's
petition.
my humble prayer, Lordship, if the time limit for completion of the investigation may be kindly be reduced, Lordship, 1 year will be a little too long, Lordship. I've suffered immensely, Lordship, because
No,
of thief raising
no,
of
they may continue till unlimited period of time.
Lordship.
That your informing
Transaction.
that may be reduced.
Lordship.
Mr. Angami, any,
Lordship, if it please your lordship, my presence may be kindly required.
it will be shown. Also heard Mr. KV Angami and public prosecutor. What is your submission regarding that?
My lordship, regarding amount.
Not
Period of only.
intimation to you?
At the minimum 10 months, my lordship.
No, then let it be 6 months instead of 1 year.
Lordship.
If you need beyond that, you have to again come to the court.
No, please, my lordship.
Instead of 1 year, make it 6 months or till investigation is completed, whichever is earlier. With above observation, this,
My lordship, investigation maybe take some time also, other linked persons are
no
there.
investigation, there is no bar.
Please, my lordship.
Investigation can
Ah.
continue till unlimited time,
Please, my lordship.
but their involvement
Their involvement
up to 6 months.
Please, my lordship.
Beyond that, if you need cooperation, you have to again come to the court,
Please.
because you cannot continue to keep them under restraint from using their own account
Please.
for unlimited time.
If anything found, then we come to court.
Much obliged, Lordship.
For admission, item number 3.
Please, my lord. Lordship, this is a subsequent writ petition. My lord will kindly come to page number 15, annexure of, no, lordship. The first writ petition is page number 13, annexure A. What has happened is, lordship, paragraph, page number 14. Here, lordship, the third paragraph, second para On 17/6/2022, this court has directed the learned government advocate to take instruction on the matter. Today, when the matter is called up, the learned government advocate has produced an order dated 4/12/2014, by which the appointment of the petitioner along with two other persons were declared null and void with effect from 30/4/2012. In view of the order dated 4/12/2014, Ms. Z. Jimomi, learned counsel for the petitioner, prays for withdrawal of the writ petition with liberty to file afresh. So here what has happened is the petitioner was appointed way back in 2006, Lordship. Then regularized.
2006,
Yes, Lordship.
just a- Yes.
This is a covered case, Lordship. Similarly, other situated persons, 19, along with the present petitioner, they were, their service was sent to Vigilance Commission for investigation on the allegation that their service appointment was forged, Lordship. However,
Forged,
for suspected forged signature.
okay.
However, others have been reinstated in service, and due to illiteracy as well as non-communication, the petitioner could not join them. So this is a covered case. Lordship, I will satisfy my lord. Allow me to start from paragraph 2 instead of explaining. Paragraph 2. That at the outset, this is a subsequent repetition of the same subject matter. The petitioner filed writ petition number 113/2022, whereof the respondent produced impugn order dated 4/11/2014, declaring the service of the petitioner null and void, which was never intimated to the petitioner in violation of the principle of natural justice. By order dated 4/7/2022, this honorable court was pleased to allow the petitioner to withdraw the writ petition with.
In the earlier writ petition also, you impugned this 4/11/14 order. But-
No, that was a new. I thought that I was in service because there,
Why you approached the court on earlier occasion?
on earlier occasion,
really-
I approached this honorable court for allowing me to continue in service with back wages, because all others got back wages along with continuation in service. They approached this honorable court, other similarly situated 19 employees. Besides, there are lots other similarly situated, but this 19 are a group, Lordship, who were alleged to have appointed on suspected forged signature, but the vigilance gave the clearance, Lordship. That's why they have been reinstated. That the petitioner could not join them, the others, Lordship. So the petitioner approached in particular before this honorable court for allowing her continuation in service and for back wages. That was provided with effect
No,
from.
why you came for allowing continuation in service? Your
Because-
service was, you were terminated,
No, I was.
you were not allowed to serve.
That's why. The termination was not served to me, Lordship. I didn't know it. So when I approached this honorable court for allowing me to continue, because other similarly situated persons who were whose salary were withheld since 2012.
No, I'm not getting.
Oh, your Lordship.
You will come to the court for allowing you to continue only if you are not allowed to continue. Only in a case you are not allowed to continue.
Yes,
Only
Lordship.
then you will approach this court.
Lordship.
On earlier occasion, you approached this court for allowing you to continue in service.
Yes, with back and my back
Back
wages
wages part,
retained,
let us forget.
Lordship, Lordship.
Allow you to continue. That means
Lordship.
you were not allowed to continue.
What has happened is, Lordship, when Lordship, there was no termination order. And we were,
And what, why you apprehended that you will not be allowed to?
because the then CMO, Chief Medical Officer Waka, said that there are some problem that has arisen in the department.
You are debarred from coming to the office
Yes, yes, yes. So I was waiting for that.
without communicating with you any termination order.
Yes, Lordship, Lordship.
Okay.
The termination order only we found out after approaching this honorable court for allowing me to continue in service. They submitted before this honorable court that I have been terminated in
On-
2014.
On 4th of July, they intimated.
Yes, Lordship.
And therefore you withdraw the.
Yes, this honorable court allowed me to withdraw the writ petition so that I could challenge my paragraph 3.
Yes.
By order bearing number so and so dated 27/11/2006, the petitioner was temporarily appointed as female attendant on ad hoc basis at Longsa Sub-Center under the establishment of the Chief Medical Officer Weka by the additional director.
Ms. Zimomi, I am taking
Yes,
2 minutes break.
Lordship, obliged. Unnecessary time waste now.
We were building an awareness. Right down the back. Oh. Is that any fun?
Check. Blue, check.
Yes.
So my lord, I will just take my lordship to the appointment order, that is, my lord can kindly come to 25C, next year C lordship. So this is her appointment order. Srimati Yansulumi Lota is hereby temporarily appointed as female attendant on ad hoc buses at Longsa, Female Welfare Sub-Center under Chief Medical Officer Woka in the scale of pay of rupees so and so for a period of 1 year with effect from the date of joining to the post.
Yes.
Thereafter, my lord will kindly come to page 26C1. Is the regularization order.
Yes.
Then this was in 2011, lordship. 2011, temporary abeyance of show cause notice issued to 73 staff under CMO Woka.
Which one? 27.
27, lordship. At that time, it was in the whole district, lordship. The Health and Family Welfare Department detected employees, those who were appointed without sanction posts, those who were appointed on land owner basis, then those who were appointed on forced signature, those who were appointed on suspected forced signature. So those were the categories that was detected, and the whole categories of employees were handed over to the State Vigilance
Under
Commission.
which category you fall?
I fall under suspected forced signature, lordship.
Okay.
My lord will kindly come. Besides others, mine is at page 28, E, annexure E. So these are the, my lord will kindly come to page 29, that is a type out clear. So we are the 19. These are the 19. We fall under the suspected forced signature. So my lord, this is government of, this is from the Vigilance and Anti-Corruption Nagaland Kohima. So this is the letter. My lord will kindly allow me to read out.
Yes.
To the Chief Medical Officer. Chief Medical Officer is the head of the district, lordship. District head of the medical department, lordship. So this was the superintendent of police asking the Chief Medical Officer Woka for requisition of documents under Section 91 CRPC.
Okay.
Sir, I am invited. This is very relevant because what has
It was not to you.
I am also here. I am at serial number.
No, but letter was addressed to CMO.
Yes, CMO.
Okay.
My name is at serial number 15, lordship. Yeah. Oh, no.
16.
No. 16.
16.
Yansulumi Lota. Yes, lordship. The other at serial number 1, 2, 3, 4, 5, 7, 8, 10, 13, 14, 15, 17, 18, 19 has been already reinstated in service, lordship. Now, here it is the superintendent of police seeking their original documents from the CMO Woka. I am invited a reference to the above subject and to state that in connection with case number RC 16/2011 registered in this police station, you are requested to kindly furnish the original appointment order copies of the following staffs who were appointed and posted under your establishment with forged signature of the appointing authority. So these are the 19 names. Then annexure 30, E1 Lordship. So this is the Chief Medical Officer responding to the Superintendent of Police Vigilance and Anti-Corruption. Subject, submission of original, this is very relevant. What has happened is that the respondent are alleging that I did not submit my original documents. That's why I was terminated from service. That is their claim. That is their ground in terminating my service, Lordship. But here, my Lord will kindly see that this is very specific. So I'm relying on this. Submission of original orders in respect of 19 staffs appointed by the Directorate of Health and Family Welfare, Nagaland, Kohima, both grade 3 and grade 4. Reference number RC 6/2011 dated Kohima the 14th October 2011. Sir, with reference to your Lordship, the type out clear one is at
31.
Yes, Lordship. With reference to your letter number RC 6/2011 dated Kohima the 14th October 2011 received only on 24/10/11. I have the honor to submit here with the appointment orders in original. My Lord will kindly appreciate that. For the following under mentioned staffs who were appointed and posted under this establishment. With utmost regret, the delay in submission of the document was due to the late submission of the incumbent posted at different health centers. So this is the original document that was submitted to the Vigilance and Anti-Corruption Lordship. My name is at serial number 16.
Yes.
Lordship, this I have made myself clear. Now,
So according to you, CMO has
already
submitted your original.
Yes,
appointment letter.
to the Vigilance Lordship. Then now my termination, they are alleging that I did not submit my original documents. How can that be? When my original documents appointment order was already submitted to the Vigilance and Anti-Corruption by the CMO. So then my Lord will kindly come to page 32 annexure F. This is the these are the employees, Lordship. That is 30th April 2012. This was sent to all the district CMOs by the Principal Director, Health and Family Welfare. Appointment made without sanction post suspected for signature. Sir, I am to invite with reference to the government letter number so and so dated Kohima the 29th June 2011 and to direct you to take the following steps immediately for further necessary action. So these are the staffs, Lordship, that is shown here that were appointed without sanction post suspected for signature, Lordship. My Lord will kindly come at the bottom. The appointment orders of this 38 staff were found to be made under suspected for signature of the appointing authority. In view of the above circumstances, the concerned controlling officer of the district are directed to held up their salaries. This is the salary comes under this, Lordship. Held up the salaries of all this 159 staff immediately since the matter is under investigation with the Vigilance and Anti-Corruption Commission. Action.
So you are not, what is your status now? You are out
Yes, I am out of service.
since
since 2014, since 2015, I was assuming because Lordship, I will satisfy my lord. Lordship will kindly come to this.
But your salary was held since April
Since,
2000.
yes, Lordship.
Okay.
Others have already gotten it. Some other similarly situated person approached this honorable court for salary. Then what has happened is this honorable court granted for payment of their salary, because this in 2015 they retrospectively terminated the employees, retrospective in 2015. So those similarly situated persons approached this honorable court in a bulk, and salary was granted to them. The government went for appeal before the Supreme Court, but the Supreme Court dismissed their appeal. So basing upon that, Lordship, others has already gotten their salary. My lord will kindly come to my, for clarity, if annexure, I will read out from my paragraph 6. I'll just read out from my writ petition, Lordship, my pleadings. So in the meantime, paragraph 6.
Just a minute.
In the meantime, by letter bearing number so and so, 30th April 2012, the respondent number 3 issued a list of 159 employees who were allegedly appointed without sanction posts and suspected forged signature, and directed the CMOs of Wokha, Kipuri, Mokokchung, Zinhepoto, Mon, Longlen, and Dimapur to withhold the salaries of 159 employees, wherein the petitioner's name appeared at serial number 16 under suspected forged signature. Thereafter, the respondent withheld the salaries of the 94 staffs under CMO Wokha, including the petitioner, and by letter number so and so dated 11 June 2012, the respondent number 4 wrote to the respondent number 3 requesting for release of salary. However, with effect from May 2012, the respondent stopped paying salary to the 95 employees, though they utilized their service. My lord, from the
This 95 includes you also.
yes, lordship. 95 includes me also.
So since May 2012, you are not getting your salary.
Yes, lordship. That is my humble prayer before the honorable court, and for that purpose, I filed the first writ petition.
Then
Sir,
when
paragraph 7.
you were terminated on 4/11/2015
Yes,
for 14,
14.
about which you came to know only in the
Only before this honorable court, they said and
in the
produced
month of
that.
June,
Yeah.
July.
So there was no notice at all. And they just terminated my service like that. I didn't know it. I thought that my salary has been withheld. So I was waiting.
But during that withholding of salary, whether you continued to work or whether you,
Of course, lordship.
is there any,
I will come to that.
Okay.
Lordship. Let me read out from my paragraph 7.
yes,
That the Vigilance Commission summoned all the alleged employees to appear before the vigilance for verification of their documents, and accordingly, they were examined and questioned. The petitioner gave her statement that she was appointed on regular basis by the then principal director, that is respondent number 3, lordship, Department of Health and Family Welfare, the head of the department, and her appointment is genuine. Subsequently, by letter number so and so dated 8 July 2013, the vigilance submitted the progress report of the investigation to the commissioner and secretary, that is respondent number 2, wherein out of 20 names in the list, only one employee at serial number 9 was referred to expert opinion and was confirmed as forged signature. Otherwise, it is inferred that the appointment of the other 19 employees were not referred to expert opinion on confirmation of their genuineness from the Principal Director, Health and Family, Department of Health and Family Welfare. My lord will kindly come to, I will, annexure G. This is
Annexure G at page.
annexure G, the relevant here, page 41. My name is at serial number 19. Out of 20. The type of copy is starting from page 42, my lord.
Yes.
So 42, my lord will kindly come to that bigger paragraph. This is progress report that was submitted to the government, lordship, by the Vigilance and Anti-Corruption, lordship. Progress report on appointment made with suspected forged signature of the appointing authority. Case number is RC 6/2011. Name of the complainant so and so. Nature of allegation. It was reported that there were instances of appointment made without sanction post, appointment made with suspected forged signature of the appointing authority. The Directorate of Health and Family Welfare Kohima order number so and so dated 18/3/2011 has therefore set up a screening board on that matter. The board has detected 121 numbers of regular appointment made without sanction post. Lordship, this is very relevant. As per the physical verification conducted from 5th to 7 June and 19 and 20 July, 12 out of 58 numbers of staffs appointed with suspected forged signature of the appointing authority. 37 employees under the CMO Wokha, Longland, Kipris, Neboto, Twengsang, and Mon has reported. I was also there, lordship. And the appointment orders of both originals and photocopies has been collected from scrutiny. Why I'm reading out this one is that here also the vigilance is saying that the appointment orders both original and photocopy, because they are alleging that I was terminated because I did not submit my original copy. That it will come later on, but that is the stand of the government in terminating my service. That's why I'm reading out this portion, lordship. And then the next page is my name is at serial number 19.
Yes.
Under CMO Wokha, my lord will kindly see that my name figures at serial number 19, page 43. Type out copy. I'm referring to type out copy, lordship.
Yes. But in the last column of serial number 19, it is
Serial number.
at page 43.
Oh,
Last,
I am 19, lordship. I beg your pardon, lordship. Serial number 19.
serial number 19.
Yes.
The last column shows that confirmed forged.
Confirmed forged. Lordship, at 10, at serial number 10, you, my lord can see page number 41. The original, this is a type out. Does not arise is there, lordship, in the original, lordship, my
Original is at page number
41. From serial number 10. Only the serial number 9 was confirmed confirmed forged, that is a little bit.
Against 11, it is does not arise.
Yes, yes,
But
Lordship.
in your type copy, you have not mentioned.
Yes, that is my mistake, Lordship. I have not, the last page. It is clerical error. So my lord will kindly come to page from page.
That is a major clerical error. Because you are saying that confirmed forged.
Yes, yes, yes. Confirmed forge is only serial number 9
In the original.
in the original.
Okay.
A Lordship. Then from serial number 10 onward does not arise. If my lord has, in my type of copy that does not arise has been
Missed
left out. Clerical error, Lordship.
Okay. Okay.
Not referred, does not arise,
Okay.
because they were confirmed that it was genuine, Lordship.
Okay.
So that is, my lord is satisfied.
The question of forgery does not arise.
Yes, Lordship, that is it. So allow me to read from paragraph 8.
Yes.
That in spite of it, no action was taken and 12 employees filed writ petition number 52K14 to writ petition number 63K14. And by order dated 18/9/2014, this honorable court disposed of the writ petition with the direction inter alia, the investigation inquiry be completed preferably by 31/1/45/15. And depending on the outcome of the investigation inquiry, the authority in the government should pass appropriate order, and that no adverse order should be passed against the petitioners without offering them an opportunity of being heard. Subsequently, 3 similarly situated persons also filed separate writ petitions, which were numbered as writ petition number 204K/14, writ petition number 205K/2014, and writ petition number 206K/2014, which were disposed of in the same terms of the order dated 18/9/14, by order dated 31/10/14 and 4/11/14. However, in spite of the direction by order bearing number so and so dated 27th April 2015, the respondent dismissed and declared null and void the service of the 29 employees, including the writ petitioners under suspected forced signature category with retrospective effect from 30/4/2012 in 2015, Lordship. It is mentioned here that the name of the present petitioner did not figure in the above dismissal list. So my name did not appear in the dismissal order. That's why I was presuming that I am still in service, Lordship. My lord will kindly come. The dismissal order is page 44, annexure H. This is the order, Lordship. This was issued on 27th April 2015. My name did not figure here. So all the salaries were withheld since 2012. The previous one I read out, Lordship. So in order, in pursuance of Government of Nagaland Department of Health and Family Welfare.
Yes. This dismissal order does not figure your name.
Yes, Lordship. So I was of the belief that I was in service because none of the employees were given salary and withheld since that 2012 letter written by the respondent number 4. So since my name did not figure here, I thought that I was in service. So my lord,
But this dismissal order is of 27/4/2015.
Yes, 27th April 2015.
But you approached this court on your earlier occasion before that.
No, Lordship, I have not. It was in a bulk, so it was in a bulk, so all the salaries were withheld. That's why I was also along with them, waiting for the outcome of the
Okay.
respondent government. So this was the outcome that
You were later on in the year 2022, you were informed that you are already dismissed on.
dismissed in 2014 when I approached this honorable court.
Okay.
Lordship, that is the my fact of the case. So, paragraph 9. That consequently, 13 petitioners filed writ petition number 157K15. Those who figured in that 19, Lordship. And writ petition number 158K15, challenging the dismissal of their service, and by common order dated 25/10/2017, the writ petitioners were directed to be reinstated in service with back wages with effect from May 2012 till 27/4/2015. Accordingly, by order bearing number so and so, dated 4 June 2018. I'm sorry, Lordship, here it's not two. I have mistakenly written 110, but this is 2018. The 13 writ petitioners were reinstated in service. Lordship will kindly come there. Paragraph 7. It is humbly stated here that the petitioner could not join the other similarly situated petitioners in the aforesaid writ petition due to communication gap, and then came COVID lockdown, and being illiterate, the petitioner lost track of them. When they approached this honorable court and got information that they have been reinstated in service, otherwise there is no willful delay in approaching this honorable court and earnestly praise, Lordship. So, Lordship will kindly come to page 46. This is this annexure I. This is the similarly situated out of 19. The last serial number 20 expired. So out of 19 employees, 13 approached this honorable court. This is 13 employees. They figured in page 42. Page 42. Those 19 employees, Lordship. Am I making myself clear, Lordship?
Page 42 is.
Those 19 suspected forged signatures.
Out of
I read
those-
out before.
Okay.
So, out of this, 13 petitions similarly situated persons approached this honorable court in writ petition 157K of 2015, page 46, annexure 1. This is the order of the court. The similarly situated, Lordship. 13. My lord will kindly come to the operative portion. Is there are long, a little long order. Page 56, paragraph 17. The operative portion, Lordship. Page 17. On consideration of the facts and circumstances as discussed herein above, my lord has got it. Page,
Yes.
paragraph 17
Yes.
of the order. On consideration of the fact and circumstances as discussed herein above, this court is of the considered opinion that the petitioners have made out a case calling for interference of this court. Accordingly, the impugned order dated 27/4/2015, insofar as the petitioners are concerned, are set aside and quashed. Those others appeared in the termination order, but my name did not appear.
Okay.
the respondent are directed to forthwith reinstate the petitioner back in service. However, the petitioner shall not be entitled to any back wages. Liberty is granted to the respondent number 3 to conduct a fresh inquiry against the petitioners if so advised. At this stage, learned counsel for the petitioner submits that the petitioners have not been paid their salaries from May 2012 till 27/4/2015. The respondent shall verify the matter, and if it is found that the petitioners have not been paid their salaries from May 2012 till 27/4/2015, the same shall be paid to the petitioner within a period of 3 months from the date of receipt of this order by the respondents.
So till the date of termination, back wages were given.
Yes, yes, Lordship. All the employees, others also approached this honorable court, and the state government went to file SLP, but that was dismissed, and so they have got it. So this is it. This was the order, and my lord will kindly come to page 57, I1. This is the restatement.
What basis this order was passed? That this order in favor of these 13 petitioners was passed on what basis? That the documents alleged to have been forged
Yes,
were found not to be forged.
Lordship, that previously I have read out here, there doesn't arise that one, the original.
Whether that has been taken into consideration in
Of course.
passing this order,
Of course, Lordship.
earlier order. Okay,
Yes, Lordship, Lordship.
okay.
And the reinstatement order is at page 57, the 13 similarly situated.
Okay. They were reinstated in the year 2018.
18 years, Lordship. In pursuant of the government of Nagaland Department of Health and Family Welfare, Nagaland Kohima letter number so and so, that the 25th April 2018. The following.
When you approached that the court on earlier occasion?
No, I have not.
No.
I have not.
The writ petition which was dismissed earlier
No,
on,
no,
on withdrawal.
no.
You approached once before this court on earlier occasion. That is your submission, that you approached this court which was withdrawn by you.
Yes, yes. In
When you approached?
2022.
22.
Yes,
So
2022.
so when, if your other 13 were already appointed in June 2018,
Yes, Lordship.
why you waited till 22?
That's why I have said, I have stated that, Lordship, there was this COVID also came. Plus, as I have stated in a paragraph that Lordship, due to communication gap, I could not join the other petitioners, similarly situated persons in approaching this honorable court that I have already stated, Lordship. Nevertheless, Lordship will appreciate that even in 2022, some other from this, not from here, but other similarly situated, those.
They were also
petitioners-
granted relief.
Yes, they were also granted relief, and some of them have been reinstated in 2022.
Okay.
I have the reinstatement orders. So my lord will kindly appreciate that they were reinstated on 7 June 2022, 13 of them, Lordship. Then my lord will kindly appreciate the last line. This is the concerned DDO is requested to prepare their salary from 1/5/2012 till 27/4/2015. However, the incumbents will not be entitled to any back wages with effect from 28/4/2015 till the date of issue of this order. This is in compliance with the Honorable High Court's order and judgment and order dated passed in writ petition number 52K 2014 to 53K 2014 and writ petition civil number 157K 2015. So these are the petitioners, similarly petitioners, 13 petitioners who along with the petitioner were in 19 of them, Lordship.
Okay.
So they have been reinstated in service, others similarly situated. Then, my lord, I also want to impress my lordship. This is page 58, annexure J. They were reinstated in 2019. These are another page 50. This was reinstated on 15 November 2019. I'm just impressing my lord that others similarly situated, different categories, some forged signatures, some appointment made without sanction order, and so on. Those who were similarly, whose salaries were withheld since 2012, they have been reinstated. They have got their salary from 2012 till 27 April 2015. That is also my humble prayer before this honorable court. Then annexure J1, page 60 is also another 11 reinstated. The first one is 9 reinstated in writ petition 85 K 2019. 9 persons reinstated, page 59. Type out copy, lordship. Page 58, annexure J is ineligible. So a batch of 9 petitioner reinstated by order dated 15 November 2019. Then page 60, another 11 reinstated in service. Then page 61, J2,
Okay.
another 7 reinstated. I want to satisfy this honorable court lordship. This is writ
These
petition.
are all on the basis of High Court's order.
Yes, lordship. So when I approached the respondents, they asked me that other have brought High Court's order, so I should also brought, and that was at that time only I came to know of it, and I filed that first writ petition. However, as I have already stated before this honorable court, that the respondent brought that I have been terminated in 2014. So that's why this honorable court allowed me to withdraw the case, so that now I am challenging that termination order, which was served without notice on the basis that
Where is your termination on?
Yes, lordship. Page 64, lordship. This is annexure L. This was never served to me, and my lord will kindly appreciate that termination. I was appointed in 2016, termination without even serving notice. So where is the question of me not producing original record that was seized by the Vigilance Commission order in pursuance of the Government of Nagaland, Department of Health and Family Welfare, Nagaland, Kohima number so and so, dated 14th November 2014. In consonance with the decision taken by the screening committee headed by the Chief Secretary Nagaland on 17th July 2013, the following personnel who have failed to produce their original documents. So this is the cause, lordship. Despite issuing notice by the letter number so and so, dated 15th May 2014, whose appointment orders are suspected to have been forged, signature of appointing authority are hereby declared null and void with effect from 30th April 2012. So this is, I am at serial number 2. Serial number 3 has already expired. Serial number 3 already expired, and her husband approached this honorable court and got the salary, pending salary, lordship. She expired while the Vigilance Commission investigation was on. So this is the letter that was placed before this honorable court in the first writ petition, lordship. Because normally this other cases were disposed of at the time of motion stage. So this honorable court instructed the respondent government to bring instruction. So when the next, it was not just a short time was given to bring instruction, and when they, at that second time, when the matter was listed, they brought this impugn order placed before this honorable court. That is when I came to know that I have been terminated in 2014. And since my name did not appear in the termination list, I was on the assumption that I'm in service.
Since when you were attending your office?
Attending the offices from 2012 till the termination. All others without salary were not paid, but along with other similarly situated, I will be seeking only that portion, Lordship.
No, tell me the dates.
That was from the date of 27th. 1 minute, my lord. Termination order. Lordship, that will be my lord, this was with effect from 30th April 2012. This was issued by the respondent number 4, Director, Principal Director, Health and Family Welfare. It was 30th April 2012 to 27th April 2015, the day when the termination order was issued to different categories of employees.
No, but your termination order was prior to that.
Prior to that. But since I don't know it, I was also clubbed up together along with all the other similarly situated lordship.
So after 27/4/2015, you did not attend the office.
Lordship, just my frank and honest submission before this honorable court, I will not.
So therefore, your claim for back wages would
Is
be
within those other people
34/2012
to
to 27/4/2015.
yes, lordship,
Ye-
3 years, like any other lordship.
Okay, and this 4/11/2014 dismissal order, you came to know only in the year
Only in 2022.
22.
Yes, when they placed before this honorable court that I have been dismissed from service. So any government servant lordship, without serving notice, principle of natural justice, the respondent cannot do that. And their allegation, their stand is, their claim is, I did not produce the original appointment order. So lordship, I have already read out from the previous communications that original order was already submitted by the CMO to the Vigilance Commission. So where is the question of me producing original documents when it was already seized by the Vigilance Commission, lordship? It is just they are trying to cover up their illegal activities.
Okay.
So this is by all others have been reinstated in service, and I have already. And lordship, if my lord, for the back wages, page 63K, I have just annexed this Supreme Court dismissal of the other writ petitioners who approached the state government filed special leave before the Honorable Supreme Court, and that was dismissed. Page 63K, similarly situated persons. In view of this order, all the other categories of employees were granted the back wages with effect from 30th April 2012 to 27th April 2015, 3 years.
This order of single bench which you have annexed at page 48,
Page 48.
whereby back pages were given to 13 of similarly situated.
Yes, yes, Lordship.
This was appealed against in before division bench in this court.
Yes, and this
Writ
honorable
appeal-
court in division bench allowed the back pages.
Okay, have you
So-
referred to that appeal, writ appeal?
Yes, so the state government, when the division bench.
No, that have you furnished the copies of writ appeal judgment, or you have mentioned
No, here I have not annexed, Lordship.
on which date that writ appeal order was passed? Because this SLPA is against an order passed in writ appeal 22/11/2017. Now, just to confirm that this SLP relates to the,
Lavano and others. These were the first batch.
this single bench appeal was appealed, the order was appealed against
Against the single bench.
before division bench.
What has happened is the first writ petitioners approached this honorable court, and this honorable court dismissed the writ petition. So in the appeal, this a group of writ petitioner approached this honorable court in the before the division bench. So the division bench, the division bench granted back wages, Lordship. So the state government went to Supreme Court for special leave.
Only against back wages. Only against the prayer of back
Yes,
wages.
yes, back
Prayer.
wages.
But prayer for reinstatement,
Reinstatement was denied to others because it is of different, those whose name appeared in the
no. You have referred to the judgment passed in WPC 157.
Lordship, shall I, division bench, since I have annexed here, I have not annexed the division bench judgment.
No, I
It
just
is-
want to understand.
Yes, Lordship.
Your submission is similarly situated 13 employees approached this court
Yes, Lordship.
whose services were dismissed, who were terminated.
No, they are different. They are different, Lordship. There were categories of employees, Lordship.
These 13,
So these 13 are, my lord will kindly come to
at annexure 46,
annexure 30,
annexure, no, at page 46.
46. Yes, Lordship.
These 13s are similarly situated like that of you.
Yes, 13, my lord will kindly come to page 28, annexure E. These are suspected for signature. There were categories. There were landowner categories. There were appointment made without sanction post categories. There were other confirmed for signature categories. So they are different from here, Lordship. Different categories. So our category is this 19. Page 28, annexure E, type out is at page 29. These are the 19 categories, Lordship. 19 suspected for signature, and later on, where the vigilance and anti-corruption found that we were
No, I have understood.
a Lordship.
Those 19s against whom the suspicion was of utilizing forged signatures.
Yes.
You
but-
were one of the 19.
Yes. So
And out of those, now let me put my query. Out of those 19, 13 approached this court.
Yes, Lordship.
Out of those 19.
Yes, Lordship. And they have.
And preferred writ petition 157K,
Yes, Lordship.
which was
That is it.
disposed of by
Yes.
granting them relief.
Yes, Lordship.
Whether state preferred any appeal against that order?
No.
State did?
No.
Okay.
No.
Then why it went to Supreme Court?
That
Only
is another categories who were not given a salary, other categories.
against this 13 orders, state did not prefer any.
No, no, no.
Okay, okay.
Besides that, others I have already reinstated in different writ petition. There was no appeal.
So that SLP is with regard to
Oh,
some
salary.
only back wages.
Big which from the previous. So basing upon that, all other categories were also granted salary.
Okay.
Besides, others,
Because the relief granted to these 13 in this writ petition was apart from back wages, limited back wages,
reinstated in service.
they were reinstated in
Yes,
service.
Lordship.
And you are seeking the same relief,
Yes, yes, we are.
reinstatement in service and limited back wages for.
Yes, only that, only that, Lordship, before the Honorable Court.
Yes, Mr. Imchen.
The respondents, only plea before the Honorable Court is that I have approached the court,
Delayedly.
Yeah, but where is the question of delay when they did not even serve me, whether delay or not? Where is the question of delay when I did not even get notice for termination of my service? So the question of delay does not come here. And this Honorable
No,
Court,
that is my question to you also,
Lordship.
that since 2015 till 22, you were not knowing that you were terminated.
Yes, Lordship.
You were also not knowing that your other colleagues approached this court and were granted relief
Lordship.
in the year 2018.
Lordship.
So from in the year 2018 also you did not came to know.
No, only after they were, it was from different PHCs and districts. So only I came to know that as I have submitted before the Honorable Court, Lordship, due to communication gap, as well as grade 4 employees, as my Lord knows that most of them are illiterate. So,
Due to, okay.
so that is it. And they are saying that I have been terminated. Their plea is that they have, and Lordship, if I would want to. This is the last 134. This is, I just want to show that they were reinstated in March 2022. The similarly situated, Lordship. Other categories. They were in petition suddenly.
They also preferred writ petition in
Yes,
2020.
Lordship. And their only stand is that we have approached this Honorable Court late, and they have cited in their own affidavit in opposition, citing one Supreme Court judgment order, that is they have cited before this in their own affidavit in opposition, the Honorable Supreme Court in AP Steel Re-Rolling Mill Limited versus State of Kerala, 2007, 2 SCC 225.
The citation is, please repeat the citation.
This citation is the respondent in their own affidavit in opposition. They have
They
cited.
have cited.
Yeah, it is
Okay.
theirs.
What is their stand?
Their stand is, that is paragraph 40, the benefit of a judgment is not extended to a case automatically. While granting relief in a writ petition, the High Court is entitled to consider the fact situation obtaining in each case, including the conduct of the petitioner. In doing so, the court is entitled to take into consideration the fact as to whether the writ petition had chosen to sit over the matter, delay, Lordship.
Okay.
Sit on the matter and then wake up after the decision of this court. It is found that the appellant approached the court after a long delay. The same may disentitle him to obtain a discretionary relief. That was what they have cited. But where is the question of me coming approaching this honorable court in delay when they themselves did not even serve me the notice. And look at their claim of terminating my service, saying that I did not submit the original appointment order. Lordship, I don't have to submit more than that. Then this is not applicable to this case. This the citation that the respondent government has given, because this is a matter of electrical tariff concession that was granted within a scheme. So after the scheme bound period was over, the petitioner approached the Honorable Supreme Court for reinforcement of the scheme that has already expired.
Okay.
So the appellant did not avail the benefit within the prescribed period of the scheme. And so he was not entitled concession. So this is not applicable to my case. This is just on electrical tariff. That is the standing. That will be my humble submission before the Honorable Court, that my case is a covered case. So I pray for just the previous back wages granted to the similarly situated circumstances and my reinstatement in service, Lordship. That is my humble prayer before the Honorable Court.
Yes, Mr. Imchen.
Or he wants to continue, or don't
We-
take much time, maybe because your lordship has understood the metrics of the case. Now I'll just take some few minutes to explain to your lordship about the stand taken by the state.
No, you can, we still have, then we'll continue after lunch.
Okay.
He will make his own case. You don't know. James. Okay. After the part of the. So, you got a comment? James. No, it's not. Because you must question. Significant. So, I want to ask for.
There is a page now.
I think it will allow for a lot of governments, pay guardians, or if not, raise it in them. Those are the children. People are already there. Where is it? Oh,
I'm very sorry for mentioning a matter, the listing.
What matter?
Matter relates to non-payment of compensation for construction of national.
So what is the urgency? Let it come up in regular course.
Things like that. So, but I'm told that on Wednesday also. there's a division it's so large, permanents.
Because tomorrow also we are very tight. Already matters are listed. Let it come up,
Wednesday,
not Wednesday,
regular course.
in regular course. You make mention,
Regular course.
who is the on the other side?
I think it's the Union of India and the government of Nagaland.
Take consent of the other side and make not so abrupt listing unless there is an urgency.
I will take the consent from others.
And then make mention.
Sure.
Yes. Mr.
Yes, Your Lordship. Your Lordship, petitioner was terminated on 4th November 2014,
Yes.
as your Lordship is well aware. And now that,
He was terminated on 4 November.
yes, 2014.
Their plea is that this termination was not intimated to them. They
No.
came to know about it only when they
That is what-
approved.
That is what I want to clarify before your Lordship. Now, when a person is serving in an office, then termination order normally come to the office. And who will believe that the petitioner come to know about his termination only in 2022? That means after 7 years only she came to know. So who will believe that preposition submission? That means she was not working, it seems. Because termination order, normally what we state to is whatever order, any order relating to an employee is served to the district office, and from there to the subdivision and all that. We don't go and personally hand over the
You
order.
have you filed any affidavit to show that it was actually served? It was.
Because that is normal course of doing things in the department.
Okay, okay.
That is
That-
number one, Your
okay.
Lordship. That means she was not there in the service, it seems, or petitioner was not attending the office. And Your Lordship,
No, the petitioner has admitted that after 2015, she has stopped attending the office.
that means he knows, petitioner knows that he was terminated.
Okay, that is your submission.
That is the thing. That is why, Lordship. That is why, Your Lordship.
But if she knew she could have, there was no reason for not assailing that termination order in her on her previous occasion when she approached this court.
That is why I have, your lordship may see my state counter. That is why I have raised the question of delay and latency, your lordship. You'll find in page 2 of the state counter, you'll find your lordship.
Your affidavit.
Page 2, para 3, Roman A. That is one contention of the state, your lordship. Is one contention of the state.
Yes.
May I read it? Roman A, para 3. For that, the service of the petitioner was terminated by Indian order dated 14/12/2014 on the ground that she failed to produce her original appointment order in compliance to the notice dated 5/5/2014. However, the petitioner is approaching this honorable court of the delay of more than 7 years. As such, the writ petition deserves to be dismissed on the ground of inordinate delay, laches, and infirmities. More so, no reasonable and sufficient cause was made out by the petitioner for condoning the delay in filing the present writ petition. The reason of delay explained in paragraph number 9 and 13 of the writ petition is unreasonable and absurd. Communication cap and COVID lockdown cannot be ground for condoning delay when the petitioner has fully slept over her rights. Further, there was no COVID lockdown during the period 4/12/2014 to 24/3/2020. Your lordship, that is the case. Because COVID lockdown was started only from 24/3/2020. From the date the petitioner was terminated till the declaration of the nationwide lockdown by the government of India. Let me read up to that extent only, your lordship. That paragraph. And now, how the state we do not take the action blindly. Your lordship may come to page 42 of the writ petition,
Yes.
Page 42 of the writ petition is the typed copy, your lordship. Page 40 is the original one. Page 40 is the original and 42 is the typed copy, your lordship.
Yes.
Here it's the 40.
Yes.
Lordship, it's a long history. It's a long history of these things. Appointment without sanction force, appointment by forging the signature of the principal director, Health and Family Welfare Neglect, which was committed during 2007, 6, 7, 8, like that. So that is why investigation was started by the authority of the state, and it was given to the state vigilance and anti-corruption. Now the findings, your lordship, you'll find in page 42, the findings of the state vigilance and anti-corruption. Lordship, page 42, the last line. The detailed particulars of the employee who were appointed with suspected forged signature are given below in district-wise. So the category of the petitioner is forged signature. That is why, since petitioner's document was forged, found to be forged, she could not produce the original one, because forged is not counted as the original. That is the reason only. Your lordship may kindly appreciate. We find that the appointment order, which was in the custody of the petitioner, was forged. That's why we sought for original. once we compared with the documents at in the department, it was found to be fraud. There was no file process. Because appointment there has to be a process. So
No,
that's,
your submission is that she has not given the original document.
since her document was forged, we find to be forged. How can that be original? Well, it was the first one. Simple as that, your lordship. You'll find, your lordship, you'll find the name of the petitioner in serial 19 here, page 43.
No, but this report shows that against the last column, opinion of expert, some documents were against some of the employees, the documents were found to be confirmed forged. Against the present petitioner, the endorsement is does not arise. What it means, does not arise. The petitioner's submission was as the document was not forged, therefore the question of
Does
opinion.
not arise, that is, relates to number 1, 2, 3, 4, 5, 6, 7, 8.
And also, this is wrongly typed. You look the original one. In the typed copy, it has been wrongly typed, forged.
It is given.
The document which you are referring to,
Your lordship, number 9, page 44.
yes,
Number 9.
confirmed forged,
Confirmed fraud.
yes. Thereafter, does not arise. And thereafter, do. That means in case of the petitioner who is at serial number 19, the question of her document being forged does not arise. That is what has been submitted by learned counsel for the petitioner.
Vigilance and anti-corruptions.
What is your reply to that submission? The documents which you are referring to helps only the petitioner. It appears. Because petitioner is relying on that document. And said document has also been relied upon to show that the original and photocopies both were collected from the chief medical officer.
Submitted to vigilance and.
Yes.
And they saying.
And therefore, that is the submission. Therefore, the petitioner failed to submit the original document to the authorities because it was already collected by the vigilance and anti-corruption. That is her submission.
My submission basing on record, lordship. It's already been read out. In the finding also it is there.
Lordship, we kindly see page 11 of our state counter, your lordship.
Of the counter affidavit.
State counter affidavit.
Yes.
This is typed copy. You'll find, your lordship will find in page 10, the original one.
The dismissal order.
But there is no mistakes here.
The termination order.
Yes.
Yes.
Now, my question is, it was given, and then in the last column, you'll find number 7, personnel's concern. It was given on 4th November 2014. Person concern is there.
Okay.
So when it is recorded, the person concerned has been given, how can the petitioner say that, no? She do not know that she was terminated.
Yes.
Worship, may kindly come to page 4, paragraph 7 of the state founder.
Yes.
Here it is, your worship, that the statement made in paragraph 4, 5, and 6 of the read petition is admitted to the extent followed by report, but not otherwise. It is respectfully stated that the appointment order of the read petitioner was found to be not genuine, since the same was issued to her by some unsurplus person in the department, forging the signature of the appointing authority. On 5/5/2014, by such and such, by notice such and such, a direction was given to the concerned CMOs, that means chief medical officers, and MS, that means medical superintendent of hospital, to trace out the original appointment order of 22 employees and submit within 1 month, wherein the name of the petitioner is reflected in serial 18. However, she failed to produce her original appointment order. Throughout the white order, dated 4/12/2014, the service of this petitioner was terminated.
Okay.
So my simple submission before your lordship is, since the document which was given by the petitioner was forged, found to be forged by the competent authorities. That's why accordingly we have terminated her. Sir. Okay. That is the reason only. So my humble submission is how, where the state, the impossible rights of the petitioner was violated by the state. Invoking this extraordinary jurisdiction of this Honorable High Court. So my submission is this petition is devoid of any merit and deserves to be dismissed. That is my humble submission before your lordship.
Okay, heard Ms. Z. Zimomi, learned counsel for the petitioner, also heard Mr. Moa Imchen, learned senior government counsel. Hearing concluded, judgment reserved.
For hearing, item number 17.
What we will hear? The IA or the
Lordship, on the last occasion, Lordship has proposed to hear the IA.
IA, but IA you are contesting. You are not yielding,
Seriously,
seriously contesting.
yes.
Okay.
I please your lordship. My lord, this IA number 84 was filed under Order 41, Rule 27 of the CPC for producing additional evidence. And the reasons for filing this application is I have stated in paragraph 2 of this application. May I take your worship to my paragraph 2 and read it out? Paragraph 2.
Paragraph 2 of your petition.
Yes. My application. IA application.
That is at page 9.
Is 3. Is 3 of IA.
The I number is, the I file would be required.
84. IN number is 84.
84. Yes,
Married lordship.
yes.
That the applicant stated before the lower trial court on 30th September 03 during cross-examination in 1969 December 5th. I know that Dutch owner and Dutch owner have sold the plot to GB Pira. I purchased the plot from GB Pira on 15 December 1969. Further, the applicant stated, I have sale agreement executed between our two parties, which can be produced before this court as and when necessary. Paragraph 3. That the documents sought to be produced
This statement was made
in the
on
deposition,
30th.
in the plaintiff deposition, this appellant's deposition, which was taken on 30th September 2003.
Yes.
Paragraph 3. That the documents sought to be produced before the honorable court are of substantial character to determine the real question in dispute between the contesting parties. 4. That the applicant tried every means to locate the sale-written documents over the years, but was unsuccessful. Also, the applicant was not aware that his son has kept his old files where past ancestral history were recorded. That the sale documents could be traced only on 31st July 2019 in the old file from his son's residence, who shifted out after his marriage sometime in 2005 and was in his possession of the same field then. Copy is annexed as ledger S1 and S2, the agreements documents. 5. That the written sale documents are documents which are required for to determine real justice and the dispute to a logical conclusion. Also, if these documents are not allowed, then substantial damages would be caused upon the present applicant petitioner. 6. That the non-production of the aforesaid documents before the trial court does not help this applicant in any manner whatsoever. And despite repeated diligent search to locate the said documents, it could not be traced. And as stated above, it was found from his son's residence. 7. That the applicant could not remember when it was given to his son, nor was aware as to when his son has taken it. The son was also not aware at all that it was in his possession, and only on 31st July 2019 When the applicant, as a last resort, went through the old files containing the past ancestral history, recovered the documents. 8. That the trial court rightly say that despite saying the existence of the sale and purchase documents, but if that is not produced in court, it would be presumed that such documents doesn't exist. However, having found the documents finally, the applicant ought to be given an opportunity to produce before the honorable court by way of additional evidence that the documents sought to be produced are relevant and substantial in character, determine the real question of the dispute. It is also respectfully stated that the seeking for production of additional documents are not to fill up the lacuna or to patch up the weak points in the case. So these are the main points. Now, the reason why this could not be located is already stated. It was in the possession of my son. Then after shifting of his residence, we don't remember where it was because it happens. Normally it happens. Now, under Rule 41, Order 41, Rule 27, the law is also very clear that normally it cannot be allowed. Let me take your lordship to CPC 41, Order 41, Rule 27. Order 41, Rule 27. It says, production of additional evidence in appellate court. The parties to an appeal shall not be entitled to produce additional evidence, whether oral.
No,
or-
when, before that on facts, when you say in 2003
Yes,
that it is with your son,
no. In 2003, I
You
said
don't
that
know.
I can produce the cell documents.
in 2019, you find out that it
Yes,
is
yes.
son
That
means
is okay.
Sanyo or Vikole is saying that it is in whom you are referring to your son,
My son,
the present.
the deceased appellant, he was
Yes.
still alive then.
So he was saying
Yes,
that
He
it
was
can be
saying-
produced.
yes.
And in 19, who is saying that it is with my son?
The plaintiff, deceased plaintiff,
This is
deceased appellant.
Vikole is saying.
Sanel. Sanel,
Sanyo is saying that
Yes.
it is with Vikole.
yes,
It is with Vikole.
yes, Your Lordship.
Okay.
Yeah.
So who shifted residence?
Vikole,
Vikole shifted.
after his
Okay,
marriage, he
okay.
shifted his residence.
Now order 40,
Order 47. Oh, sorry.
41 rule
Order
27.
41, Rule 27. Production of additional evidence in appellate court. 1. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. It is not allowed, but if A, the court from whose decree the appeal is referred has refused to admit evidence which ought to have been admitted. This is not our case. A, the party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appealed against was passed, or B, the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. So my submission would be on AA and B. Now, AA is, despite my diligent efforts, the document could not be traced.
until 2019 September. Now, the second one is B, whether this document would be required for the Honorable Court to pronounce judgment or for any other substantial cause. Now that, so discretion is given to the court. Normally, it is not permissible, but discretion is given to the court, and it is purely up to the court, depending on the facts and circumstances of the case. Therefore, because of circumstances, this exception has been provided by the amendment of the CPC. It is not simply to allow somebody to produce a document at the later stage, but we have to fulfill these conditions. And the court has to see that this is evidence, seeking for additional evidence is also important for pronouncement of judgment. So the rule says the appellate court may allow such evidence or document to be produced or witness to be examined. And close to whenever additional evidence is allowed to be produced by an appellate court, the court shall report the reasons for its admissions. Therefore, since I have submitted my reasons, this is the only reason, and I have already stated that it is there, but I could not locate it. Despite the fact that I have stated that it is there, I could not produce it for a long time. Now, if I don't produce it, it does not give me any benefit. So if I found it, if I have it at the time when I gave my deposition, if I don't produce it, despite having that in my hand or available, then it is to my disadvantage.
When
only.
the judgment was delivered in this case,
Your Lordship,
when the impugned judgment was delivered,
it was delivered on
17.19.
so your case is that you found it after the delivery of judgment.
yes. It was recovered in September 31st, 2019. Now, Your Lordship, my submission is short, and I would like to rely on some of the authorities pronounced by the Supreme Court. The first one, in fact, Your Lordship, a copy of the authorities relied upon has already been given to Your Lordship. And so, but if additional copies required, then I'm ready. Otherwise,
It may be there.
flag C. First would be flag C. Paragraph 4 and 6. Paragraph 4. Your Lordship has got it. Flag C. This is
Yes.
1997 Jaipur Development Authority. Paragraph 4. It says, we are of the view that the interpretation put in by the High Court of Rajasthan and the High Court of Gauhati on the word additional in clause AA of Order 41/27 CPC is not correct. Then paragraph 5, the provisions of Rule 27 of Order 41 insofar as they are relevant read as follows. Production of additional evidence in appellate court. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. But if AA, the party seeking to produce additional evidence, establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appealed against was passed, or the appellate court may allow such evidence or documents to be produced or witnesses to be examined. Paragraph 6. The intention of the sub-rule in our view is that the party who, for the reasons mentioned in the sub-clause, was unable to produce the evidence in the trial court, should be enabled to produce the same in the appellate court. The sub-rule mentions the conditions which must be complied with by the party producing the additional evidence. Namely, that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or would not, after the exercise of due diligence, be produced by him in the trial court. It is not one of the conditions that the party seeking to introduce additional evidence must have also been one who has left some evidence in the trial court. Such a view amounts to introducing an additional condition not contemplated by the sub-rule. No distinction was intended by the sub-rule between a party who has produced some evidence in the trial court and one who has adduced no evidence in the trial court. All that is required is that the conditions mentioned in the body of the sub-rule must be proved to exist. It is not permissible to restrict clause AA for the benefit of only those who have adduced some evidence in the trial court. Your Lordship, in this, our Gauhati High Court, if I'm not wrong, I think I've come across this, our Gauhati High Court judgment, that if some evidence has been already adduced, then as per the court's view, additional evidence may be admitted. But there's, and Rajasthan is just the opposite. So the Supreme Court says neither of that is right. The only question is whether the conditions of, in this case, it will be AA, whether that has been fulfilled. And then you lost it. Next one is like E, paragraph 36 and 38, like E. Paragraph 36. The general principle is that the appellate court should not travel outside the record of the lower court and cannot take any evidence in appeal. However, as an exception, Order 41, Rule 27 CPC enables the appellate court to take additional evidence in exceptional circumstances. The appellate court may permit additional evidence only and only if the conditions laid down in this rule are found to exist. The parties are not entitled as of right to the admissions of such evidence. Thus, the provisions does not apply when, on the basis of the evidence on record, the appellate court can pronounce a satisfactory judgment. The matter is entirely within the discretion of the court and is to be used sparingly. Such a discretion is only a judicial discretion circumscribed by the limitation specified in the rule itself. 38, paragraph 38. Under Order 41, Rule 27 CPC, the appellate court has the power to allow the document to be produced and a witness to be examined, but the requirement of the said court must be limited to those cases where it found it necessary to obtain such evidence for enabling it to pronounce judgment. This provision does not entitle the appellate court to let in fresh evidence at the appellate stage, where even without such evidence, it can pronounce judgment.
No, what this phrase means, for enabling it to pronounce judgment. what it means.
It means that on the available documents or available evidence already placed before the court, if the court can make a satisfactory pronouncement of the judgment, then the court also may not allow that the introduction of additional documents or evidence. But if the court feels that the documents seeking to produce as additional documents is required for proper judgment, then the court can allow it. So that is the discretion of the court. And Your Lordship, this is not reported, but this is a recent case in 2022 by the Supreme Court. This is not reported, but this is one of the latest case. So in this, I would like to rely on paragraph 4.
Yes, paragraph 4.
This is unreported, paragraph 4. It is true that the general principle is that the appellate court should not travel outside the court of the lower court and cannot take any evidence in appeal. However, as an exception, Order 41 Rule 27 CPC enables the court to take additional evidence in exceptional circumstances. It may also be true that the appellate court may permit additional evidence if the conditions laid down in this rule are found to exist and the parties are not entitled as of right to the admissions of such evidence. However, at the same time, where the additional evidence sought to be adduced removes the cloud of doubt over the case, and the evidence has a direct and important bearing on the main issue in the suit, and the interest of justice clearly renders it imperative that it may be allowed to be permitted on record. Such application may be allowed. Even one of the circumstances in which the production of additional evidence under Order 41 Rule 27 CPC by the appellate court is to be considered is whether or not the appellate court requires the additional evidence so as to enable it to pronouncement of judgment, or for any other substantial cause of that nature, of like nature. As observed and held by this court in the case of so-and-so versus so-and-so reported in the 2015-76 SCC, the admissibility of additional evidence does not depend upon the relevancy to the issue on hand or on the fact whether the applicant had an opportunity for adducing such evidence at an earlier stage or not, but it depends upon whether or not the appellate court requires the evidence so to be adduced to enable it to pronounce judgment or for any other substantial cause. It is further observed that the true test, therefore, is whether the appellate court is able to pronounce judgment on the materials before it without taking into consideration the additional evidence sought to be adduced. So it is very clear. Now you will see regarding the procedure, this is a procedure, and I would like to refer to that also, a short paragraph. Like D. Appellate para 26. 6 and 31.
Yes.
Paragraph 26. Since this is a procedural aspect, I wanted to refer to this. Laws of procedure are meant to regulate, effectively assist and aid the object of doing substantial and real justice, and not to foreclose even an adjudication on merits of substantial rights of citizens under personal property and other laws. Procedure has always been viewed as a handmaid of justice and not meant to hamper the course of justice or sanctify miscarriage of justice. A careful reading of the provisions contained in Order 22 CPC as well as the subsequent amendments thereto would lend credit and support to the view that they were devised to ensure their continuation and culmination in an effective adjudication and not to retard the further progress of the proceedings and thereby not suit the others similarly placed as long as their distinct and independent rights to property or any claim remains intact and not lost forever due to the death of one or the other in the proceedings. That up to that much. Then paragraph 31. But in our view also, as to what those circumstances are to be, cannot be exhaustively enumerated, and no hard and fast rule for invariable application can be devised. With the march and progress of law, the new horizons explored and modalities discerned, and the fact that the procedural laws must be liberally construed to really serve as handmaid, made it workable and advance the end of justice. Technical objections which tend to be stumbling blocks to defeat and deny substantial and effective justice should be strictly viewed for being discouraged, except where the mandate of law inevitably necessitates it. Up to that much, Your Lordship. Therefore, in the fact and circumstances of the case, the reason for not producing before the trial court is it could not be found at the when it was required. It was recovered, found only after the appeal was filed. As a last resort, when we went through the files of the ancestral property records, it was found there. There is no intention to avoid the production of these documents because it does not serve any benefit to the appellant. On the other hand, since evidence is already there, although that may not be a criteria for allowing the additional evidence. Now, the appellant himself has stated in his depositions, as well as deceased witness Lechone, he also stated that he has been sold to, the property has been sold to the deceased appellant. Therefore, there are circumstances, and if this is allowed as an additional document, then certainly it will also assist the court to come to a finding, whether it is right or wrong, whether this in what way the final disposal of this appeal would be deliberated. So that is an important factor. Therefore, my submission is that this additional evidence may kindly be allowed in the interest of justice. That will be my submission, Your Lordship.
When can you produce this additional evidence, assuming that if it is allowed?
Your Lordship, now all are dead. Original documents I have already produced, which again we have taken back, but still it is there.
Who will exhibit it? I'm
Now-
putting queries without
No, in that
Without
case, the son.
please don't
The
take any
legal-
indication that it may be.
Yes,
allowed.
yes, Your Lordship. The legal
I am just-
representative,
Suppose it is allowed,
yes.
then when can you exhibit it? What would be the procedure? This court can itself take it,
Of
or
course,
it can send it to the trial court. This,
It can be sent to a trial court by fixing a short date, because it should not take time.
or whether this court itself can take it. That is my.
This court also can take it. Both ways.
What is your,
It is to be sent back to.
what is the difference of this court sending it to the trial court and this court taking it itself?
The only difference will be the time factor, maybe 2-3 days difference. Otherwise, if it is to be sent back for that only, then it can be. fixed
No,
a date and
otherwise
turn
there
it.
is no other impediment, question of appeal revision, that is not there. Suppose this court itself takes it,
Yes,
is whether any right of any parties is affected. Because
any party.
order 41 rule 27 says that the appellate court may also take
Yes,
additional evidence.
yes, yes,
But normally we have seen that High Court does not itself takes.
yes.
Why it is so?
Your Lordship, because
Both of
Perhaps
you are
because
very
the
experienced,
court is
therefore I
going
am putting these questions.
because the court is going to pronounce a judgment, so perhaps they prefer that somebody take that one. That may be, in my view, that may be a reason,
Okay,
yes.
but otherwise legal bar is not there.
Legal bar is not there, certainly it is not.
Who will be exhibiting that document? Your prayer is only for exhibiting that
Yes,
sale deed.
yes.
So some witness would be exhibiting.
The legal representative. Because the appellant, the original appellant has died, my father has died, so that person. The Kole, we can.
Bekele, the present appellant.
Yes.
Okay. One more thing.
Yes.
Suppose this court allows it,
Yes.
when Bekele can exhibit it?
Within
If
2-3 days,
If it fixed tomorrow,
tomorrow, yes, we can.
day after tomorrow, you have no,
Preferably day after, because he has to come from Fuchero. So
that is a
preferably-
query.
Yes, preferably day after.
But on that count, you don't have any other objection. That it has to be after this much of time, period of time. You don't have any objection, suppose if your petition is allowed and you are asked to exhibit it in this court. Say,
Yes. No, I have no objection.
okay,
I have no objection.
okay. That were my queries only. Yes, Mr. Zamir.
Yes, Mr. Lords. Like my learned friend, my submission will also be short. My learned friend has read out his application, but 2 paragraphs I would like to refer, which will be relevant for us. That is
Of the-
paragraph
Of the
of his
application,
application, that is IA 84 of 2019. In paragraph 2, there is a categorical mention about a date that is 30th September 2003, if I remember correctly. I'll just check up.
Yes.
Yes.
On that day, he deposed that he has this document
Yes, he has that document.
and he can produce it as and when required.
Yes. It is like a child narrating the story, though her parents, as and when parents comes, when the mischief has been done by the child, and then immediately child is aware that the parents will definitely punish him. Therefore, he is concocting a story to satisfy the parents what mischief he has done. It is like that. Now, Lordship has taken note of the date, that is 30th September 2003. That was a trial, during the trial, which was conducted by no other than the District Judge Kohima. That was in the first April number. This was not a civil revision number 1 of 2000. Now, besides that, I would like to draw your Lordship's attention to paragraph 4 of his application, same application. I may be allowed to read this again at the course of repetition. Paragraph 4, that the applicant tried every means to locate the self-written document over the years, but was unsuccessful. Also, the applicant was not aware that his son has kept his all files where the first ancestral history were recorded. That the self-document could be traced. This will be very important. These 4 lines. That the self-document could be traced only on 31st July 2019 in the old file from his son's residence, who shifted out after his marriage sometime in 2005 and was in his possession of the same till then. Since he has already made the statement in 2003, 2 years are very relevant, that is 2005 and 2019. 2005 is a year when the learned ADCJ Kohima has passed the order in a trial. Decree was also passed. And 2019 is a year when the trial was conducted by the ADCJ PEC. And prior to this, there was a judgment of this Honorable Court in 2017, where this Honorable Court has directed the District Judge PEC to go for a fresh trial. So in order to cover up all this, meticulously, this 2005 and 2019 has been designed. In what manner it is designed, can this come to the appeal memo at page 76. This is the order of the Additional Deputy Commissioner, which was passed on 28/11/2005. Page 76. This is the operative portion.
28/5/2011.
Yes. 2000. Page 69, Lordship will find the judgment. Starting part 28/11/2005 in civil revision number 1 of 2001. So Lordship may kindly come to the operative portion. So Lordship, correct. I'll just refer to the relevant portion, that is page 76, second paragraph. The paragraph starts with from all the above foregoing discussion. Does
Yes,
your lordship got
Yes.
that portion?
yes,
Let me read that portion.
yes.
From all the above foregoing discussions, the court finds the same issues raised all go in favor of Kiriti Bureau, the plaintiff respondent. The sale purchase of 1969 from Tachuni and Vichuni by the petitioner. This is the one which they want to exhibit, lordship. Has discrepancies and no documentary support. Vichuni, one of the original owner of the land in question, who survives Tachuni, is not a trustworthy witness himself. Documents rendered by Tachuni in his lifetime indicates his fallacious statement. No prosecution of his rights by the petitioner for 10 long years, which was in litigation over a plot just adjacent to his building, seriously jeopardizes any testimony of the purchase of 1969. No mention of the same was ever made by Tachuni or Pichuni in the previous proceedings over the same plot till 1985. This is the year from which the present appellant came into picture. When the present petitioner is introduced to the dispute, see, prior to 1985, he was not in the picture, even in the litigations. Purchase of land may be taken place, but the date is distorted. The law also does not permit resale of the same plot to a different person. Vichuni must bear all its consequences. Now, again, kindly come to page 94. To see what he has stated. Page 94 of the appeal memo. There are only 3 paragraphs. I would like to refer, 4 paragraphs. I would like to refer to the second last paragraph. It was sometime in 2003 or 2004 when the trial was conducted before the district judge Kohima. Second last paragraph, the paragraph starts with, let us go from second paragraph. This was during the cross-examination. In paragraph starts with in 1969. As your lordship got it?
Yes.
In 1969, December 5th, I know that Pechuni and Tachuni has sold the plot to GBP.
Who is this? Who?
Tachuni and Pichuni.
No, this is the deposition of
The deposition of the appellants. Present
Vic-
appellant.
Vekole. Sanyo.
Sanyo Kiso.
Sanyo.
Present appellant's father. Original appellant.
Okay. This Sanyo has stated.
Yes. So,
Yes.
so, next paragraph. I have sell agreement exhibited. That is, I think, executed.
Okay.
Executed between our 2 parties, which can be produced before this honorable court asked and when necessary. This was in 2003. Now, when he has made the statement, he was very much aware, appellant was very much aware that there is a sale date. That was in 2003. He has made that reflection. And the same thing, lordship, may kindly come again, page 77. Before this honorable court also, they have made a similar. This honorable court has made an observation. Page 77 is the starting part of the order. This is the order dated 10/7/2017. Passed in first appeal number 1K of 2006. This appeal has been filed by the present appellant against the order, judgment and order passed by the ADC J. Kohima. Lordship will
Yes.
kindly come to page 87 and 87. I will just take your lordship's attention to the relevant portion only. Has your lordship got it?
Yes.
Page 87, last paragraph. The paragraph starts with, it appears. It's a sopara paragraph 9. It appears from the statement.
Yes.
Has your lordship got it? I will read from this portion, lordship.
Yes.
It appears from the statements given by the witnesses that neither the nor the parties in dispute were aware of the fact that to prove their respective case, they have to exhibit all the documents on which the claims are based upon and prove the same too. Further, from the submissions of both the learned counsels, also it appears that there was a misconception on the part of the parties regarding the way how secondary evidence is to be produced and proved to keep the same evidential value. The ambiguous judgment and order of the trial court also shows that the learned additional deputy commissioner J. Kohima was of the understanding that it is sufficient if a document is filed and exhibited. When contending parties are equally well entrenched against each other in the terms of evidence will make the difference or be the documentary evidence. They are exhibited and proved. In this case, as stated above, the appellant in the deposition stated that he had a self-deed agreement and he can produce it as and when necessary. Likewise, in the case of the respondent also, he seems to have depended upon documents which were not even exhibited. In view of what has been stated above, I am of the view that to do full justice, the parties must be given a chance of proving their respective case properly. I am aware that this dispute has dragged on for a long time, but it would be better for both the parties and for the ends of justice to have the case tried properly as per law, so that the litigation finally comes to an end. Therefore, the ambiguous judgment and order is set aside, and the district judge is directed to try the case afresh by giving the parties a chance to exhibit and prove all the documents on which they want to rely on for their respective case. To do that, further examination of the witnesses already examined may be required. And if so, the witnesses already examined may be allowed to give further evidence in respect of the documents. So this was by this Honorable Court on 10/7/2007. 2017, sorry, thank you. This statement has been made even before a High Court. When the trial was conducted in fact, pursuant to the order passed by this Honorable Court. Lordship has said the direction of this Honorable Court is very clear, allowing the parties to adduce all the evidence and documents, whatever they want to exhibit. Liberty was given, and they are also aware of this judgment, passed in 2017. And thereafter only trial was conducted. If they are diligent enough, if they are serious, they could have furnished this. They have not explained.
Their plea is, it could not be traced out.
How they have searched, what they have done, it is not stated in the application.
Okay.
Merely by making a statement, by calculating the dates, what date will be relevant, they have taken up and then placed. And 2003, the evidence was given. The ground taken by them is his son got married in 2005. Thereafter, normally, as per our custom, till a person is married, normally they stay with the parents. And after marriage, they may go to a separate house and they will live. Family will live. So their contention is that that has been discovered from his son's residence only, because it was all along kept in his son's residence from 2005 to 2019. But the fact remains that on 30th September 2003, he has made the statement already before the court that I shall furnish, there is a safety, and I shall furnish as and when it is necessary. So it was in his house. And after the son's marriage in 2005, son went out of the house. Maybe that time they have taken all the documents. What discussion they had, I don't know, during that time. But as per the statement mentioned in the application, his son married in 2005, and from 2005 to 2009, it was not found traceable. When trial was conducted in PAC, they could have exhibited that document. Because the order of this honorable court is very clear that parties may exhibit all the documents, any documents, whatever they wish to remain. That liberty was in 2017. Thereafter only the trial started. And they have not tried to find any document during that time. And more importantly, Lordship, in the appeal memo, in the entire appeal, there is no problem that they tried to exhibit, but court has stopped them. It is not your case. So ample opportunity was given, afforded, but if a party do not avail that opportunity, who will help? He has to suffer for his own lapses. Again, can we come to page 159, Lordship? Page 159 of the appeal memo. This was the finding of the trial court PAC, district judge PAC, and this is the ambient order. And under issue number 3, this point conclusion has been arrived by the trial court. Page 159, the last paragraph starts with further. Whether Lordship has got it?
Yes.
Yes, may I approach? Further, this court has also taken into consideration of the effective that during proceedings, Mr. Senyo Kizo has not exhibited any self-deed to substantiate his claim. 2, Mr. Pechuni, while divorcing as RW number 1 in previous proceedings, have testified that self-deed agreement may be there, and Mr. Senyo Kizo as RW3 have categorically testified that self-deed agreement was executed and can be produced as and when necessary. However, no self-deed was produced and exhibited while trying the case afresh again by this court. See? In all the proceedings, the present appellant was making a submission that I have a self-deed, I will furnish as and when it is necessary. Then what prevented him to furnish the self-deed during the trial? Now, can we come to the provisions of law, Lordship? My learned friend has already read out the provisions, and Lordship is also well aware about these provisions. But in short, Lordship, Order 41, Roll 27. My learned friend has fairly considered with the clause A that it is not relevant. Yes, that is very much correct. We have nothing to do with the clause A. Otherwise, production of additional evidence at the appellate stage is part under Order 41, Rule 27. But 3 exceptions were given, and those exceptions, provisos. A, it is not relevant for us because there is no grievance. It is not a grievance that if you wanted to exhibit it, but the court has stopped them, so it could not be exhibited. That is not the case. So it is irrelevant. A will be relevant. And here, Lordship, kindly see. The party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence is very important. Way back in 2003, he said that there is a sale deed, and till 2019, he could not trace out and made any effort to trace out that document. Can it be said that due diligence has been exercised? There is no explanation in the application also. Such evidence was not within his knowledge.
No, how to find out whether due diligence was?
See the connecting, Lordship. Notwithstanding the exercise of due diligence, such evidence was not within his knowledge. It is not a case that it was not within his knowledge. It was very much within his knowledge, so far as our case is concerned.
Yes.
If it is not within his knowledge, then that is okay. But way back on 30th September 2003, he said that I have a sale deed. That means the existence of a sale deed is very much within his knowledge. No other person has said that I have a sale deed. It is the appellant himself who said that I have a sale deed. When? 30th September 2003. Therefore, due diligence was not exercised. The due diligence will be applicable only when you do not have the knowledge about the existence of such document. Then yes. But here in our case, it is just the reverse. It was very much within his knowledge since 2003 about the existence of a sale deed, and he could not exhibit it till 2019. That is, due diligence was not exercised, or could not, after the exercise of due diligence, be produced by him at a time when the decree appeal against was passed.
In second clause, though knowledge is there, or read after or could not.
Or could not.
It relates to if a person has knowledge, but after due diligence, he could not produce.
After exercise of due knowledge be produced by him, it talks about the possibility of producing the document by him, even after exercising. But that was not made possible. Where is that statement then? I have exercised due diligence. I have tried my best. I have given full efforts, but it was not possible for me to purchase because I was there in Delhi. I was there in London. Is it the case? No. See the pleadings.
So whether due diligence was there or not is to be found out from the pleadings of the.
Yes.
What has been narrated to show due diligence?
The grounds taken in the application. What are the grounds and reasons they have given? The only reason given is his son's marriage in 2005, and till 2005 to 2018, since it was lying in his son's house, he could not trace out. That is what the pleading says. I will, Lordship, before going to other details, I would like to complete the provisions.
Yes.
Order 27. Clause B. This is towards your Lordship side. The appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. Suppose some documents for pronouncement of judgment. This is with a previous lordship, clause B. This is for what? For pronouncement of judgment. By whom? By the court. If any difficulty is faced by this honorable court for pronouncement of judgment, then this honorable court will direct the parties to produce certain documents. Or if necessary, evidence will be taken. Or any substantial cost. Therefore, the document which they want to rely should have a substantial cost so as to exhibit this document. Now, in order to do all this, see the following line. The appellate court may allow such evidence or documents to be produced or witness to be examined. And clause 2, this will be again important. Wherever additional evidence is allowed to be produced by an appellate court, the court shall record the reasons for its admission. Why this clause 2? Because the starting part of Order 47, Order 41, Rule 27 is that production of additional evidence in the appellate stage is part. There is a part in the appellate stage. Lordship is hearing an appeal, and there is a direct part, but only on limited grounds. These three grounds, A, and B. Court has the discretion to allow under certain circumstances, but that should be governed by clause 2. Wherever additional evidence is allowed to be produced by an appellate court, the court shall record the reasons for its admission. Therefore, this honorable court should be satisfied that yes, unless this document is placed or produced, I cannot pronounce the judgment. Therefore, reason is to be recorded by this honorable court for allowing to exhibit or to admit the particular document. Now, what is that document? Coming to the point. Which document do you want to exhibit? We have enclosed in the application page number 7. That is the original, and then type copy is at page 8 of the application. I will not go into detail, only the year will be relevant. It is of agreement about the sale 5/12/1969. And then again at page 10, Lordship will find another agreement, that is 15/11/1969. Both the documents are pertaining to 1969. I'm not referring to the dates. We are concerned with the year, which is more relevant. In response to the application, objection has been filed by the respondent. And I would like to refer to that affidavit. It's a short affidavit, objection. Lordship may kindly come to my objection.
There are how many documents which is sought to be exhibited?
Oh, two.
Two.
Both are of 1969. These are the two documents. So far as the disputed plot is concerned, I got it allotment from the government way back in 1972 only. And till 1985, the first appellant, that is Sanyo Kizo. In all the records, Lordship will find Sanyo Kizo, who is no more, so he has been substituted by his son. The fact remains that till 1985, Sanyo Kizo was not in the picture altogether in the proceeding, entire proceeding. And the present suit lead has been obtained by the present respondent in 1972 only from the medical department. Adjacent land, Sanyo may have purchased long back. Who knows? 1969 document may be talking about this fraud. And by twisting the frauds, the present appellant filed an application before this honorable court for directing a spot verification that was also rejected. That no. Because before the trial court, they have filed an application for a spot verification, but that was also denied because there was no justification. It was only playing to delay the matter. Therefore, that was also rejected. Now, the 1969 document, they are trying to exhibit this before this honorable court or to the trial court. They want to exhibit this as one of the documents. So the provisions of law of Order 47, Rule 27, provisions are very clear. The reasons for what purpose this has to be exhibited, exhibition is necessary, but above all, even assuming this honorable court is going to allow the appellants to exhibit this document. This document of 1969 is not a registered document at all. Therefore, what purpose will be served also by sending it for exhibition also? It cannot be exhibited. Lordship is aware about the implication of Section 17 of the Indian Registration Act, which is very much applicable in the state of Nagaland, and about the compulsory registration consequences of non-registration of the document under Section 49 of the Registration Act. There is a direct bar under the law. Under Section 17 of the Indian Registration Act, documents which are compulsory, and this is an immovable property conferring title to the parties. Therefore, the document falls under the compulsory registration under Section 17 of the Indian Registration Act. Moreover, the implication of Section 49 of the Registration Act will come where if a document is not registered, it cannot be taken as a piece of evidence in any proceeding. Therefore, how will it help them? But if allowed, it will cause high prejudices. to the-
Section 49 bars admissibility of unregistered
Yes.
document.
Yes. Ethic of non-registration of document required to be registered. No document required by Section 17 or by any provisions of the Transfer of Property Act 1882 to be registered shall, and then C will be relevant, shall be received as evidence of any transaction affecting such property or conferring such power unless it has been registered. So there is a direct part. Now, I would like to refer to my objection. It's a short objection. I will just read out the relevant provisions. I have quoted the provisions of the section, but these are not relevant, so I will not read. So kindly come to my objection also.
No, before that,
Yes,
before that.
yes,
The bar is as regards sale deed.
yes.
If, but this is not a sale deed, this is an agreement. Or the appellant is treating it to be sale deed.
They are treating it as a sale deed.
This is not a sale deed. Sale deed is different. But this is only agreement.
If it is not a sale deed,
That land
it
has been
is
given
probably
to them.
better for me. What for this agreement is necessary so as to decide it. If it is not a sale deed, irrelevant. Absolutely irrelevant.
If it is an only agreement.
Yes. They may have met so many agreements. How do it affect me? Even otherwise also, even if it is exhibited, it is prior to 1972.
So if it is only an agreement, then this document
Will not comfort a mini right?
will not, no. I have to test on, there are certain tests. Test is that I may not be able to pronounce judgment without this document. If it is not a sale deed, that it would not affect in any manner.
Yes.
Had it been a sale deed, question would have been different.
Yes.
That is your submission.
Yes.
Okay.
Because we should not forget the provisions of law. What is the requirement of law? Then now may I take your lordship's attention to the objection? Or if any clarification?
One more clarification. This ground in AA and B, 27(1) small AA.
Yes.
Three grounds are there, A,
Yes.
AA and B. These
Yes.
are three exclusively separate grounds or interlinked. These are separate grounds.
Yes.
That means if the grounds mentioned in AA exist, court may allow. Or if grounds mentioned in B exist, court may allow.
Yes.
It is not necessary that AA and B both should exist together. Okay.
Yes. If one is attracted, then yes, this honorable court will have the power. But at the same time, we should not forget clause 2.
Like here, there is a broad category is given for any other substantial cause.
Yes.
This is an enabling
Yes.
cause.
Substantial cause means it should have a direct relation with the case so as to decide the present case.
Okay. Substantial cause means it should have a direct relationship with.
Yes, with the issue involved in the case, which is not involved in our case.
Okay.
In other words, this cannot be treated as a substantial one, substantial to come. And Lordship will remember about the statement which he has made way back in 2003 and the order passed by this honorable court in 2017, where ample opportunity has been afforded to the parties concerned. Therefore, it all supports, combining all these supports that the present appellant is trying to delay and prolong the matter. Tomorrow, if it is sent back to the trial court, you don't know what new grounds they may like to bring.
The court.
May I
can
come to
prevent
that?
For that,
May I come to that?
the court can prevent that.
Objection, Lordship. Only the relevant
Yes, Your-
portions I will point out. Page 2. Paragraph 2. A. B. That's your Lordship correct?
Yes.
Let me read A. That the present case between the appellant and the respondent has been agitated in various courts for more than 34 years, and various orders have been passed to that effect. However, despite the span of time and filing of number of cases in different courts in connection with the plot of land in question, and at the same time of taking evidence, the present appellant failed to produce any documents in support of his claim, and as such, on the basis of the available documents as well as the evidences, the ambient order dated 17/5/2019. This is the ambient order. Was passed by the district judge Peck. Prior to this, there was another trial in 2005 by the district judge Kohima, where the decree was also passed in favor of the respondent. B. That after the ambient judgment and the order dated 17/5/2019 was passed by the district judge Peck, the applicant has preferred an appeal being first appeal number 2K of 2019 against the aforesaid judgment and order dated 17/5/2019, which is pending before this honorable court. When the matter is pending before this honorable court, the appellant has filed the present interlocutory application under Order 41, Rule 27 of the CPC to produce agreements dated 15/11/1969. The said agreement dated 15/11/69 is for the first time producing before the appellate court after more than 34 years of dispute between the appellant, and the respondent in the various courts. This 34-year is counting from 1985 only, when the present appellant came into the picture. Otherwise, there was cases prior to that also, few litigations. And then C is with regard to the provisions which we have already read. I'm not reading. So page 3, last paragraph. In this connection, it is stated that in order to adduce additional evidence, documents before the appellate court, one must fulfill the above mentioned criteria laid down under Order 41, Rule 27 of the CPC. However, in the present case, the appellant is filing the present application seeking the leave of this honorable court to bring into record of a document after more than 34 years of litigation between the same parties. The appellant was given enough opportunities to produce these documents when the matter was pending at different forums for the last more than 34 years. Admittedly, the appellant was not diligent and omitted to produce such documents, which was within his knowledge for the last more than 34 years. Now it is belated stage. If this documents is allowed to be produced before this appellate court, there will be never-ending litigation, and as such, this honorable court may be placed to reject the present application for the ends of justice. D, page 4. That the applicant has produced an agreement dated 15/11/1969, allegedly executed between Pichuni and Piri, wherein it is stated that the year 1969, I, Mr. Pichuni, has sold my plot below the dispensary, facing towards the road to Mr. Piri, and there is no dispute over the land at rupees 460. The said land was resold to Sanyu Kizu by Piri on 4/12/1969. We are concerned with the year, that is 1969. In both the cases, I, Piri, on 15/11/1969 purchased the land from Pichuni Vero, the dispensary plot facing towards the road, had resold the same to Sanyu Kizu at rupees 460. There is no dispute over the plot of land. A bare perusal of the said two agreements, the location of the plot of land sold to Piri by Pichuni and the plot of land that has been allegedly resold to Sanyu is different. Therefore, this honorable court may not allow such conflicting documents to be produced before this honorable court. E, that as regards the disputed land, the respondent white letter dated 10/5/1972 has submitted an application to the Director of Health Services, Nagaland, Kohima, praying for acquisition of all dispensary quarter type 3 at Puchuru. In the said application, it is stated that now the quarter is vacated by your department since the last 1 year, that is 1971, and the building is now in a dilapidated condition as repairing is not undertaken. A land certificate was also issued by the GP of Kikruma village, as well as ESC of Puchuru. From the above facts, it is clear that the said dispensary was vacated only in the year 1971, that is after 1969. And the disputed land is about this land. F. that even assuming that there exists an agreement dated 15/11/1969 between PD and Senyo Kizo over the disputed land, the same is null and void because of the fact that when the said agreement was entered between the parties over the said land, the same was under the possession and occupation of the Department of Health Services, that is up to 1971. In view of the above, the present interlocutory application for production of additional evidence document is not sustainable in law, and as such, the same may be dismissed. Now, appellants are talking about the sale in 1969. The suit loan was vacated by the medical department only in 1971. And occupied by allotment was given and occupied by Kiriti Vero, that is the respondent, in the year 1972. Therefore, the question of the present suit land in 1969 does not arise also in that case. So, if this honorable court, by ignoring everything, the provisions of law, what has happened, what are there in the records, by forgetting everything, if a direction is issued also, what purpose will be served? At one point of time, they tried to, many times, not only at one point of time, 2-3 occasions, they were trying to show that this land, no, this is not the land. Actually, this is the disputed land. This is not the one. They want to twist the land as if the land has legs to walk. But then, that was the plea since 70s, 80s. But then this honorable court has said, no, that is not correct. That order is also accepted by the present appellant, not challenged. So it remains on record of this honorable court also that no, it is about the same land which the Kiriti Vero was occupied. But when the present appellant was the officer in charge of the Puchoro police station, he constructed in violation of the order passed by this honorable court, constructed the building and earning the revenue till then. If an excavation is done, even at present, in it, there will be sand, there will be iron rod, which were kept by the present respondent. Those are the facts, but it has nothing to do with this present case. But those are the things which has happened in connection with this case. And all along, the appellant has been successful in prolonging the matter. And the execution proceeding is pending before PEC. But in view of tendency of this present appeal, the execution proceeding could not be proceeded further. So it's kept pending. Now, to conclude my submission, Lordship, I will just I would like to refer to section 96, under which the present appeal has been filed. Section 96 deals with the appeals from original decrees. So accordingly, they have filed the present appeal. But Lordship may just have a look on clause 3 of the section 96, which says about no appeal shall lie from a decree passed by the court with the consent of parties. There are few areas, few points, issues where the parties have also agreed that no dispute. On those points, it cannot be considered. The present appeal cannot be considered because they are stopped to raise such points when they have already given consent before the trial court and also before the Senate court. That is one. Clause 3 of section 96. Now, the other day, Lordship was also raising a point, which I feel it to be also relevant. And
for this,
no, for the main. Lordship, if I remember correctly, Lordship was mentioning about the technical deficiencies of the trial court. here
No,
and
no.
there.
I have queries,
Yes.
but that I have already posed. Now, whether to dispose of this IA first or to,
Once this IA is allowed, then the hearing of the main appeal will be meaningless.
meaningless means
Meaningless means it will be.
It will be
futile
delayed.
exercise. It will be futile exercise. And so far as provisions of law is concerned, and so far as records are concerned, all the points are against the appeal. All the points. This is nothing but to delay the matter. Lordship may examine the records, examine the provisions of law, and arrive to a conclusion. Because whatever I have to submit, I have already submitted. And to the possible extent, I have also referred to all the relevant records. Now, I was just trying to reply on that point, section 99. No decree to be reversed or modified for error or irregularity not affecting merits or jurisdiction. So during the trial, in the trial court, there may be irregularities, lapses, technicalities here and there, but those are not the grounds unless it is touching the merits of the case and with regard to the jurisdiction. Therefore, Lordship, from all counts, on all counts, the present appeal is meritless and it is deserved to be dismissed so as to prevail justice, Lordship. And the judgment which my learned friend has referred to, the last judgment which my learned friend has referred to, 2022 case my learned friend has just referred to, Lordship may kindly see, relevant to decide the issue. So any document allowed by the appellate court to produce should be relevant to decide the issue involved in the case. And if it is not relevant to decide the issue in the case, that is irrelevant. And so far as the present case is concerned, the citation which has been cited is not relevant. And Lordship was putting a query whether any party will be prejudiced by adducing this. Definitely the respondent will be prejudiced, highly prejudiced, if this IA is allowed, Lordship. Now, to substantiate my submission, Lordship, I would like to refer to a few judgments on Order 41, Rule 27. Additional evidence after a long time is denied. 1980, additional evidence.
yes,
After a long time, denied. 1980, 1 SCC 412, paragraph 8. That is Pramod Kumari Patia versus Om Prakash Patia. And on the general principle, on the basic principles of admission of additional evidence, one important judgment of the Ethics Court, 1987, 1 SCC 227, paragraph 27. Sivaji Rao Nilankikar Patel versus Mahesh Mathap Kosavi. That is 1986. Basic principle of admission of additional evidence on that point. Third, no admission of new documents after much delay. That will be similar to the first one. 2001, 7 SCC 503, paragraph 8. And paragraph 19 also will be relevant. And then next, this is all an order 41 rule, rule 27 additional evidence. Discretion of appellate court to allow production of in exceptional circumstances should be exercised sparingly, not in a routine manner. Should be exercised judicially and with circumspection only where any of the prerequisites of conditions provided under Rule 27 exists. And there must be satisfactory reasons for non-production of the evidence in trial court. Lordship, that will be important. There must be satisfactory reasons for non-production of the evidence in trial court for seeking production thereof in the appellate court. That is 2012 8 SCC 148 paragraph 36 to 49. Union of India versus Abraham Putin and others. And then 2023 judgment. I am furnishing this. It is already the Lordship I have furnished. 2023 19632. Court cannot remand back merely on the ground that a particular evidence has not been adduced. Court cannot remand back merely on the ground that a particular evidence has not been adduced. That is 2023 ACC online SC, that is Supreme Court 196, and no remand for TNO votes in the judgment.
Okay.
Now that parties have been allowed to exhibit all the documents, sufficient opportunity was given. And if that opportunity was not availed by the parties concerned, how at the appellate stage should allow? If it is allowed, then it will be in violation of the proviso provided under Order 41 Rule 27 Lordship. So at the appellate stage, the power under Order 41 Rule 27 should be exercised sparingly with circumspection. And it should not be allowed as a routine manner. I conclude my submission.
Just a little clarification. My letter friend has referred to page 76, referring to the earlier judgment passed by the ADC Judicial Kohima, Sri Hukato. Page 76, second paragraph. Here she referred to this one, and referring to this second paragraph. Now the court. What the court says, from all the above forward discussions, the court finds the issues raised all go in favor of the receiver of the plaintiff respondent. The sale purchase of 1969 from Dutchman and Veterinary by the petitioner has discrepancies and no documentary support. Veterinary, one of the original owners of the land in question, who survived Veterinary is not a trustworthy witness himself. Now, this deposition, the deposition of Veterinary was not deposed before this court. Now, what under what circumstances this demeanor of the witnesses come up? No reason was given. And next slide, documents rendered by Dutchman. Dutchman was never a witness. He is not a witness. And the demeanor of a witness can be gathered only by the court which recorded the deposition of the witness. Similar mistake was committed in the present appeal also. Then, according to my friend, points are all against me. Evidence are all against him. Because we have to go by evidence. Because the respondent, the present respondent, he says in his deposition.
Lordship has already heard and made it.
No, we have
My
not
learned
discussed
friend
it.
is making
We
submission
have
on
not
merit.
discussed the issues
Let him
and
submit in the IA.
we have not discussed the evidence of the witnesses. And your lordship has seen that when your lordship was in Mizoram, to go by the issues again.
No.
And he
Today,
has referred to the witnesses' depositions.
only with regard to whether additional evidence would be required or not, only with regard to that limited questions, not on.
No, your lordship also has talked about the issues. Because last time we have
No,
not gone by
those
the
queries
issues.
will be relevant only after
Yeah.
I dispose of this. I'll be disposing of this I first.
Your lordship, in that case, I conclude my submissions.
Otherwise, what is your submission? And what is your, that if this IA is allowed, you will be able to adduce evidence within 1 or 2 days.
To exhibit it, yes.
Okay, heard Mr. R. Iralu, learned senior counsel assisted by Elivil Zhao. Also heard Mr. C.T. Zamir, learned senior counsel appearing for respondent side, who is assisted by Mr. N. Longkumar. Let this matter be listed on 16, 17, 18th.
Yes.
18 for delivery of orders in IA.
Yes.
First, let us dispose of the IA.
Yes, your lordship. All right, your lordship.
And in main case, main appeal, list this matter again on 18th of. This will be, what will
18th.
happen, this will subject to what is the outcome of the IA.
Yes.
List this, show the presence of counsel, list this matter again on 18th of October.
Obliged, your lordship.
18 is
Day after tomorrow,
day after tomorrow will be witnessed a DBT
DB, after DB,
Yes,
after TB.
we will sit.
yes.
I have some engagement in some other.
No, on
That's
that day, hearing may not occur. I'll pass orders on this matter.
That's good.
Obliged.
For hearing item number 21.
Albert, this I would take home today. Item number, we still have hearing matters. Do we have time in hand to? How much time will you take?
Your lordship, I'll take some time, more than 30 minutes.
Yes, can we? If we don't have time, let us fix it on some other day.
Lordship, either that or if there are too many fixed matters tomorrow, then in that case, after vacation.
Again, same thing will happen. Let it come up after vacation. Mr.
Okay, Your Lordship.
This is item number
21.
But heard Mr. T. Kezi, learned counsel for the petitioner. Also heard Mr. E. Tibafom, learned senior government counsel, and you are appearing for?
I'm for respondent 4, your lordship.
What is your name?
Krike. Cricket.
Right hand name. Your name is not shown in the cause list.
It's shown, Your Lordship. Cricket Thono. KHRI.
Oh, Cricket Thono.
THON.
Cricket Thono. Learned counsel for respondent number 2. Due to paucity of time, this matter could not be taken up today, as the hearing may require some time. Hence, let this matter be listed after 2 weeks.
Bless you, Lordship.
For hearing, item number 24.
Lordship, this matter was listed on Friday, Lordship. And
How much time will you require?
Lordship, on facts, I may take only 20 minutes, Lordship, and on the question of law, maybe five minutes, Lordship.
You have half an hour only.
Lordship, if your Lordship may accommodate, or if at a convenient, if it can be taken up tomorrow also, Lordship. Otherwise, my matter is very simple, limited to regularization, Lordship.
What is the, because I have.
State has also filed their affidavit. They are very clear with their stand, Lordship.
This is regarding what? Okay, let us hear.
Lordship.
If it remains, what is your submission, Mr.?
My lord,
Can we go ahead?
okay, I'll take only 5 minutes.
Okay.
Very short submission.
Okay, then let us hear it.
Lordship. Lordship, in very simple, I'll
Just
make,
a minute.
make
Just-
the facts very
Item number?
24, Lordship. 24, supplementary hearing, Lordship.
Yes,
Lordship, there are altogether 3 petitioners, Lordship.
3 petitioners.
Yes,
are-
Lordship, all 3 petitioners. They are all serving as LDA cum computer assistant, Lordship, under the Department of Social Welfare, Government of Nagaland, Lordship. All of them, they were appointed on contract basis, Lordship.
Contractual employees.
Yes, Lordship, contractual employees.
Yes,
Lordship, their appointments will be, Lordship will find it page 21, 22, and 23. They were all appointed on contract basis, and they were appointed on separate dates, Lordship. If I may be allowed to apprise the date of appointment, Lordship,
yes.
page 21, Lordship.
Yes. 21,
Yes, Lordship, page 21, Annexure A. Lordship will find the type copy at the next page, 21A. Type copy, Lordship. This is dated 1st of February 2012, Lordship. Appointment of the first petitioner, Lordship.
yes,
The appointment is purely on contract basis, Lordship. And this next annexure, page 22, Lordship will find the appointment of petitioner number 2. This is order dated 11/4/2013.
okay,
And Lordship will find the appointment order of the third petition at page number 23. This is order dated 4th September 2013. So more or less the mode of appointment is the same, Lordship, all contractual basis, Lordship. as on today, Lordship, they have completed more than 10 years. The petitioner petitioner number 1 has completed 11 years and 7 months.
P1 is 11 years, 7 months.
11 years, 7 months, Lordship. Petitioner number 2 has completed 10 years and 4 months.
Yes.
And petitioner number 3 has completed 10 years and 1 month, Lordship. This is the length of service, Lordship, they have served. No, Lordship, I'll come straight to the office memorandum, Lordship. 2008 office memorandum, page 24. I'm relying on this office memorandum, Lordship. There are 2 office memorandum, Lordship. The first is office memorandum dated 4th August 2008, page number 24, Lordship. It is a 1-page memorandum, if I may be allowed to read it, Lordship.
Yes.
Subject is regularization of contract ad hoc appointments against sanction post. In supersession of this department memorandum of even number dated 18 August 2004 and dated 23rd August 2007, the Governor of Nagaland is pleased to order that contract employees may be regularized by the departments who have completed more than 3 years of continuous service. Lordship, this is very important. On contract or ad hoc basis against sanctioned posts only. However, such regularization of contract ad hoc employees shall not apply to posts where there are pending court cases or where the posts have already requisitioned for filling through NPSC. In our case, Lordship, there is no pending court cases except the present petitions, or it has not been requisitioned through the NPSC to fill up through the NPSC, Lordship. The following terms and conditions will be applied for regularization of the contract ad hoc employees. 1, there should be a sanctioned post. This is the first criteria, Lordship. Second is the employee should fulfill all eligibility criteria for the post, including the requisite education qualifications. And 1, this OM shall not apply to posts where there are pending court cases. 2, this OM shall not apply where the posts have already been requisitioned for filling up through NPSC. The suitability test is also important, Lordship. Should be conducted by the concerned departments under the chairmanship of the head of the administrative department, with representative from the PNR department and ATI Nagaland Kohima. Qualifying marks should be laid down in advance, and only those who qualify such as screening tests should be considered for regularization. So that is the screening test that has been provided in this OM. There should be a sanctioned post. There should not be any pending court cases, or the post should not be requisitioned through the NPSC, Lordship. Now I have stated, Lordship, in my petition that I was appointed against sanction post. The government has also filed the affidavit. They have admitted that position, Lordship. Now coming to the second office memorandum, Lordship. Lordship will find it page number 30, Lordship.
Page number
30, Lordship. The Lordship got it.
Yes.
This is office memorandum dated 11 August 2016. These are the 2 office memorandum I'm relying upon, Lordship. Subject is ban on appointment on contract basis, Lordship. Now the relevant portion of this office memorandum is para 3, Lordship. Para 3. Keeping in view the ban on appointment on contract basis and need to clear earlier cases pending for regularization, it has also been decided that the cases of government employees appointed on contract basis prior to the ban notified PNR so-and-so, 6/6/2016 shall be taken up for regularization on completion of 3 years of continuous service on contract ad hoc basis in terms of OM number so-and-so 4/8/2008. That is the earlier OM I have relied upon, Lordship. And in supersession of OMs dated 2010-2015. This has the approval of the cabinet-wide memorandum number dated 12th July 2016. Subsequently, what has happened, Lordship? A suitability test was conducted, Lordship. I have also participated, and they have stated that I qualified the suitability test, Lordship.
Suitability test for regularization.
Yes, Lordship, for regularization was conducted.
Okay.
In terms of the office memorandum 2008 as well as 2016, Lordship. Notification was issued at page 31, Lordship, if you Lordship may kindly turn to the next page, Lordship. This is the department. The secretary has issued this notification pursuant to the office memorandum, Lordship. This is notification dated 6 October 2006, Lordship. May I read it, Lordship?
Yes.
In pursuance to PNAR department OM number so-and-so dated 4/8/2008, the governor of Nagaland is pleased to constitute a committee with the following members to conduct suitability tests for regularization of the contract employees who have completed more than 3 years of continuous service against the sanctioned post under the Directorate of Social Welfare as under number 1, Secretary Social Welfare as the chairman, 2, Secretary Representative from PNR as member, Director ATI as member, and the 3rd, 4th is Director Social Welfare as member secretary, Lordship. It was the committee was constituted. After that, suitability test was conducted, Lordship. Now then, Lordship will find the next page, Lordship. After conducting the suitability test, the Joint Director has written to the government, Lordship, seeking approval for regularization. After qualifying the test, Lordship, page 32, Lordship, may I read it?
Yes.
This is communication dated 14 December 2006. Subject is approval for regularization of contract appointment. With reference to the aforementioned subject, I am directed to forward here with the meeting minutes of suitability test conducted for the following post. 2 posts of CDPOs, 1 probation officer, 15 supervisors, 1 matron, 1 caretaker, 9 posts of LTA computed. This is in regard to the present petitioner's, Lordship, and 6 drivers and 12 peons, Lordship. Recommended by the committee, the list further furnished below is proposed on the basis of merit for future seniority, Lordship. Now, Lordship will find the names of the petitioners at page 34. Result of suitability test which was conducted, Lordship. Page 34. If you
You are
Lordship
at
got it.
serial number?
Petitioner number 1 with serial number 3, Lordship. Petitioner number 2 at serial number 6, and petitioner number 3 at serial number 2. And this test was held on 30th of November 2016, Lordship. 30th of November 2016. This has been issued on the basis of merit, Lordship. So this shows that all the 3 petitioners, they have qualified that the suitability test. The director has forwarded to the government seeking approval for regularization, Lordship.
Then what happened?
Lordship. Now, page 36, Lordship. This is with regard to segregation, Lordship. The Joint Director has addressed, Lordship. May not be pertinent for this case, Lordship, but a segregation was sought by the petitioners for delay of considering for regularization, Lordship. What has happened, Lordship, while pending this for approval from the government, Lordship, a case was filed, Lordship, by account, Lordship, that is against corruption and unabated taxation. That is, it is an association. They filed a writ petition challenging these 2 OMs, Lordship, 2008-2016 OM, Lordship.
Okay.
It was numbered as WPC 145K of 2017, Lordship. I have enclosed the judgment in my petition, Lordship, and Annexure L, page 39, Lordship.
What happened?
Lordship, by filing this petition, Lordship, WPC 145, several numbers of appointments were being challenged. And also the office memorandum, 2 office memorandums were also challenged, Lordship. What has happened, Lordship, while disposing? It was dismissed on the question of maintainability, Lordship. On the question of maintainability by the
WPC was dismissed.
Yes, Lordship. Question of maintainability. On the question that the petitioners should qualify to challenge those posts, Lordship. They are just members of an association, and they do not qualify to challenge all those posts, Lordship, under various departments, Lordship. So on that ground, it was dismissed on maintainability. However, Lordship, when the single judge dismissed the petition, the OM, the port to OMs were also discussed, Lordship. If I may be allowed to.
Something has been observed.
Yes, Lordship. Yes, Lordship.
Yes.
Yes. Lord. May I take your Lordship to the relevant paragraph of the observation?
At
Page 74, Lordship, paragraph 29 of the judgment, Lordship. Page 74, Lordship. Observation has been made by the single judge. If your Lordship got it,
Yes.
paragraph 29, may I read it, Lordship? The petitioners will have to show that they are aggrieved by the appointments made. Thus, they will have to give material particulars to challenge the appointments made, keeping in mind the relevant recruitment rules. The petitioners have, however, made a sweeping challenge to appointments made in various grades of posts pertaining to approximately 25 government departments, Lordship, altogether 25 departments, thereby trying to brush aside all alleged irregularities and illegalities with one sweep of the broom. It is very difficult for this court to sift through the facts of this case in the absence of complete material facts. In respect of the challenge made to 706 alleged irregular and illegal appointments, the petitioners will have to file separate petitions making a challenge to the various appointments by giving specific particulars. As their grievance relates to different appointments in various departments of the government of Nagaland, further, this writ petition cannot be decided piecemeal. They shall have to implead all persons whose rights may be affected by the petitioners. In view of the reasons stated above, this court finds that the present petition is not maintainable in its present form. The state respondents should, this is very important, Lordship, with regard to the office memorandum, the state respondent should not regularize any person if he has completed only 3 years. This is very important, Lordship. The term used only 3 years of continuous service on contract ad hoc basis in terms of office memorandum dated 11/8/2016 and OM dated 4/8/2008. This is the observation, Lordship. If the employee has completed only 3 years, this service should not be regularized in terms of the OM, Lordship. However, this is very clear. If I may be allowed to complete, Lordship, the last paragraph. The petitioners are, however, given the liberty to make a fresh challenge to the appointments of the impleaded respondents and other persons as per law. As the present writ petition has not been dismissed on merit, but only on the issue of maintainability. With regard to the contention of respondents that the issues has been settled by order dated so-and-so and PL number so-and-so cannot be reopened by the petitioners, as the order dated so-and-so passed in PL number 1115 has attained finality. This court finds that the order dated 5/8/16 passed in PL so-and-so can be applicable to the petitioner number 1 only and not to the other petitioners. Now, only an observation was made with regard to the office memorandum. It was not quashed and set aside, Lordship. So my contention, Lordship, my respectful submission before this honorable court is that the 2 OM still holds the field, Lordship. That's my.
So after this observation by High Court,
Lordship.
state
Stopped. Preferred an appeal, Lordship. Preferred
against
an
this
appeal.
order.
Yes,
No.
Lordship.
After the suitability test,
Yes, Lordship.
your matter was referred to the government for approval.
Approval. Nothing has happened, Lordship, after that.
Then why government did not act? What is the plea of the government?
Government was of the contention that since this PIL is pending before this honorable court, they cannot consider, Lordship. However, the OM has not been indifferent, Lordship. Lordship has also seen the observation made by this single bench of this honorable court. After that, nothing has happened, Lordship. I have waited for so many years, Lordship.
Oh. Time is over.
Lordship.
How much time will you take? You are done with,
Lordship, only with regard to the.
or we may take it, continue tomorrow.
Lordship, if your Lordship may kindly accommodate.
We may keep it to tomorrow as part heard,
Lordship.
because I have a VC meeting now with principals here.
Lordship.
Heard Mr. Moaz Zamir, learned counsel for the petitioner. Also heard Mr. E. Tiba from learned senior government counsel. The hearing remained inconclusive. Let this matter be fixed again tomorrow, that is on 17th October 2023 as a part heard matter.
Lordship. Much obliged, Lordship.
Much obliged.
It is item number 17 to Judge Laboratory.
Just load it, no? Just load it.
This is 70. This is listed tomorrow, 79. So they are tomorrow evening. And what item you are talking?
619,
70 is 620.
over.
For delivery of order,
Yeah.
and it be,
Baba,
be,
have you signed
for
up for
delivery, item it, I will.
or
For
if
delivery.